insights, real-world experience, and forward-looking strategies. So each session will be followed with a brief Q&A. So if you're joining us virtually, please feel free to enter your questions into the chat. I'll be monitoring the chat throughout the sessions. And then for your own planning purposes, we'll be taking a break from 1:30 to 1:45. And then just some housekeeping. Following the session, we'll also have a fun trivia game called Kahoot, where you can answer some trivia questions about each session. When there's a QR code that appears on the screen, you can scan it on your phone to participate, and we'll be crowdsourcing some of the responses, and there'll be some fun little prizes, which you see up here. Just as a reminder, this will be the prizes will just be for in-person attendees only, unfortunately. But also a reminder that this event will be recorded and can be used for CLE credit. So without further ado, let's get right to it. Kicking us off is Amanda Johnston and Katy Herman with What's Brewing in Compliance, a session diving into hot topics and enforcement trends impacting FDA-regulated companies. If that doesn't work, you can use this one.
How do I turn it? Oh, there it goes. I said ope. Good afternoon. It's great to see everybody here in person and all the people online. Really appreciate you coming out. Like Darya said, the sun is actually out today, which is lovely. Katy and I are going to give kind of an update in a kind of a briefing style on some cases, some notable cases as of late in the fraud and abuse area. And then we'll leave some time for questions. All right. I guess we'll briefly introduce ourselves. Amanda Johnston, I'm a partner at Gardner Law. Been here for about 6 years. Before coming to the firm, I worked in-house at Coloplast, Medtronic, United Healthcare, in various compliance and regulatory roles. And here I split my practice between compliance and regulatory. And I'll let Katy give herself a brief introduction as well.
Yeah. My name is Katy Herman. I am an associate attorney with Gardner. I have been with the firm for about just over a year now. Prior to Gardner, I worked in-house at Coloplast, supporting in both legal compliance and also contracting functions in both the manufacturer side, but also their DME entity. And at Gardner, my focus is mainly on compliance.
All right. With that, we'll go over quickly just kind of the topics we're going to talk about today. We will do a brief overview or refresher on kind of the key fraud and abuse laws that we're going to be talking about. We'll talk about kind of last fiscal year from a DOJ perspective and what that False Claims Act recoveries and settlements looked like. And then we'll talk about going forward. So what are the DOJ priorities from a compliance, fraud, and abuse perspective? Where should companies be focusing? Also emerging themes. So again, kind of drawing from what we've seen so far and what we've seen in the past year to come up with some themes that will be emerging or are emerging. We'll do some case spotlights and then time for Q&A. All right, so just a quick refresher, primer. Really the two main fraud and abuse laws that we're going to be talking about today are the False Claims Act and the anti-kickback statute. The federal versions we're going to be focusing on. So first, the False Claims Act, as we all probably know, again, it prohibits knowingly submitting false or fraudulent claims to the government. So it's broader than the healthcare industry. Some of the common themes that we see are theories of liability under the False Claims Act, off-label promotion, medically unnecessary billing, improper billing. Those are the themes that we'll see, and we'll see those in the case summaries as well. And then the anti-kickback statute, which is a criminal statute, so it's a felony, and it prohibits the offering, giving, receiving of anything of value in exchange for referrals for services or products reimbursed by federal healthcare programs. And why these matter, and we'll see in some of the cases, these are used together. So these two statutes working together really are the focus of the DOJ. As it relates to sales practices, marketing strategies, and then financial relationships with HCPs. All right, so just quickly, you guys may have seen this, but in February, the DOJ released their summary of fiscal year 2024, their enforcement actions from False Claims Act perspective. Total settlements and judgments for fiscal year 2024 was $2.9 billion, and that was up slightly from the previous years. But really, what stands out here is the number of qui tam lawsuits that were filed last year. 979, that's the highest in history, and it's continuing to grow. This is a big area of income for the government. Total settlements and judgments since 1986 is $78 billion. And then the total cases resolved last year, 558, that's the second highest. So we've seen kind of a steady increase over the years. In my opinion, the most notable is just the continuing rise of qui tam lawsuits. All right, so then just what the DOJ is saying. So there's been a lot in the news over the last few months. There's been a lot of change, a lot of commentary made, but one thing that I think will not change is the DOJ's focus on the False Claims Act enforcement. So in a speech in February, they again reiterated that they will aggressively enforce the False Claims Act. As you can see on the previous slide, it's a big moneymaker for them. But also its principles align with the new administration's goals to reduce fraud, improve efficiency, and prevent fraud, waste, and abuse, and ensure accountability. Some of the emerging questions, again, I don't have answers to these, but it will be interesting to see if we see any DEI-related qui tam suits come up, or if we see any DEI-related, theories of liability coming to fruition. I haven't seen anything to date, but it will be interesting, DEI, but also if there's additional executive orders or focuses on different types of practices. So that's kind of an open question still. All right, so key themes, and this is kind of looking back, but also kind of predicting based on what we're seeing and what we're going to talk about today. False Claims Act enforcement it's apolitical. It's bipartisan. Generally, we've seen, everybody wants to root out fraud, waste, and abuse, and then they're making a lot of money in the settlements, and it's accelerating. Whistleblower activity, as I mentioned, is at an all-time high. So I only imagine that will increase. Mark and I were at a breakfast this morning, and we were talking to some attorneys in the space, and we were speculating whether there'll be more cases filed with the use of AI. Any whistleblower could go on to ChatGPT and draft up a complaint. So is that going to make an impact? Possibly. Commission-based rep models. So if you guys remember, there was a Mallory case. We're going to talk a little bit about kind of what's happened since that. But that's still kind of an area of enforcement, and I know that it's very common among medical device companies and pharma companies. So I think we will, continue to see scrutiny in that area. And kind of the garden variety, we're going to continue to see speaker programs, financial arrangements with HCPs. We are going to, we've seen actually an increase in kind of FDA-related safety, labeling, quality cases that have been prosecuted from a False Claims Act perspective. And we have a couple today that we'll talk about that were pretty recent. But that's interesting. We're seeing, again, not the FDA necessarily taking action, but it's being prosecuted from a False Claims Act perspective. And then we have some emerging areas, which we will talk about in the case summaries, but Medicare Advantage, telehealth, genetic testing, diagnostic testing. So these are kind of the themes that we are seeing based on last year's and kind of this upcoming year, fiscal year from a DOJ perspective. Now we will dive into some of the recent cases. And I'll pass it over to Katy to talk about, so we have kind of themes. Mm-hmm. The first theme or bucket is kickbacks and charitable foundations. And I'll let Katy take it away.
All right. So in our first bucket, our first case, as Amanda said, we'll go through this kind of brief style, but the first case is related to Teva Pharmaceuticals. So they agreed in a settlement with DOJ to pay $425 million for a copay kickback scheme. So the government alleged in this instance that Teva conspired with multiple third parties, including specialty pharmacies and two allegedly independent codependent or copay assistance foundations to direct support provided to the foundation directly to patients taking their MS drug, Copaxone. So from 2006 to 2017, they coordinated with the third parties to steer those donations while continuing to increase the cost of Copaxone by thousands of dollars. So the allegations allege violations of both the AKS and FCA. Key takeaways here are that the DOJ is targeting use of charitable foundations to mask kickbacks. Those Medicare copays that were being funded are truly intended as a cost control by Medicare, and they are not to be bypassed by pharma or medical device companies. And copay assistance has to be tied directly to, or copay assistance tied directly to prescription volume is an AKS risk.
And this one was one of the few that was not a key TAM, which is interesting.
Correct.
It was a DOJ-led.
And this was the largest copay assistance and charitable foundation settlement to date. This activity within copay assistance, the U.S. Attorney's Office has collected more than $1.4 billion just from this initiative alone.
Wow. All right.
All right, so next up, Pfizer has agreed to pay $60 million for Biohaven kickback allegations. So in this context, Biohaven, prior to acquisition by Pfizer, had engaged in activities alleged to induce prescriptions of their Nurtec OTD, their pharmaceutical product. The payments included honoraria, high-end meals, and repeat speaker programs where individuals were coming repeatedly to the same program, finding limited or no educational value, and also included individuals who had no need to join, such as spouses, colleagues, and other individuals. And the government alleged that all of these payments were made with an intent to induce prescribing behaviors. So the speaker programs in particular were a high value item and what the government focused on. The conduct did end when Pfizer acquired Biohaven and shut down the programs, but there was still settlement related to it. So takeaways include this reinforces DOJ scrutiny of speaker programs. We previously saw the OIG special alert on speaker programs, and DOJ is continuing to focus on these. And then reminder that intent matters. Educational value has to be genuine. It cannot be with the intent of marketing. You have to structure it, and the intent and the educational components have to be valid and bona fide.
All right, and this was a key TAM case.
Correct, and that the realtor actually received $8.4 million from her federal recovery.
Does it say if it was a sales rep or employee or anything?
It was an employee.
Okay.
I believe she was a sales rep.
Okay.
But to highlight the monetary incentives for key TAM relators as well.
Yep. And I just pause quickly. I was at a pharma conference or it was the pharma compliance conference in the fall, and one of the speakers from the DOJ or from the OIG actually had said, watch for speaker program settlements, there's gonna be more coming, and then sure enough, we've seen a couple now. So we'll talk about this next one, which is a key TAM.
Yep, so again, DOJ targeting speaker programs, US v. Gilead. In this context, they were alleged to have paid more than $23 million in kickbacks via honoraria, meals, travel, to physicians for 17,000 plus speaker programs from 2011 to 2017. Again, we had instances of repeat attendees having little educational value, and these events were held in lavish venues such as the James Beard House, including multiple course meals, alcohol pairings, and travel perks. The government claimed that these events were often attended by people, again, repeatedly coming in and having little to no educational value, and therefore likely intended to induce the prescription of the products. The other of note, Gilead's compliance monitoring failed to detect or prevent abuse despite internal warnings. So in this context, the legal theories were AKS violation through the False Claims Act. Key takeaways here, DOJ continues, again, to target speaker programs as kickback vehicles, looking at and making sure that you have proper controls as to event venues and ensuring that everything is fair and balanced and fair and appropriate, and reinforces the need for robust monitoring on that fair market value and documentation of engagements with HCPs. All right. And then the last case in this bucket we're going to discuss, or set of cases, relates to commission-based reps and the legal landscape related to it. So as Amanda alluded to, the first case that we'll look at was Mallory. So the Fourth Circuit held that the volume-based pay to a 1099 or an independent contractor sales agent violates the AKS, and it is not permitted to fit within a safe harbor. But subsequent to that, in two separate cases, Sorensen in the Seventh Circuit and Marchetti in the Fifth Circuit, they determined that volume-based pay to independent sales reps is not automatically or is not per se illegal under AKS. They're really focusing on the intent and then whether or not those sales reps had the ability to influence or induce those individuals. So from a takeaway perspective, 1099 commissions have historically been risky. I think it will continue to be risky, but they are not inherently banned or not per se illegal. The key risk factors are going to be determining whether or not direct contact with the prescribers exists, whether or not they're acting on behalf of HCPs, and whether or not they're separately reimbursable items. We would also consider de-risking via policy limits and restructuring, and making sure that your contractors are being paid in a way that limits this risk.
Yeah, we routinely get questions about this because it's kind of a weird, environment in that so many startup companies have contractors that are sales reps. That's just, we can't afford to hire full-time employees right away. So we do get a lot of questions about this, and we, help them try to come up with an agreement or arrangement, whether it's, setting maybe less on commissions and more on like training targets or educational targets or that kind of a thing. But ideally, you want it to fit in within the personal services safe harbor, but it's hard. You can't do that if it's based on the volume and value. So still kind of up in the air, but we now have two separate circuits that have said it's not per se legal. So we'll keep an eye on that trend. All right, and then I'm going to talk a little bit about kind of the next bucket, which is off-label and safety risks. So the first case is Diopsis. So this is a medical device company out of Pennsylvania. This was brought as a qui tam lawsuit actually from an ophthalmologist, so Dr. Jane. Diopsis has a vision testing system, NOVA, and it is cleared by the FDA for visual evoked potential testing, VEP testing. And that is when they put electrodes on your brain and they show like your eyes certain stimulus, and then they measure the detection of or how your brain kind of lights up based on that. They were allegedly promoting it for use as a electroretinography is what they were using it for. And that's when you put the electrodes either on your eyes or around your eyes and you're measuring retinal reaction to visual stimuli. So different anatomical location, different intended use. They didn't have clearance for the ERG, I think it was called ERG, electroretinography. And then they also had thrown in that Diopsis had made some modifications to their vision testing system that should have had a 510K, but they failed to submit and get clearance for the modifications. So that was also raised in this settlement. But essentially, they were encouraging providers to use it, allegedly, for this different indication. And again, it was a qui tam case, so one of the doctors who probably, presumably had heard or seen kind of that communication. So yeah, they settled for $14.25 million. Dr. Jane, the whistleblower, gets $207,000. Really the takeaway is we are seeing, again, kind of more, we've seen a number of off-label cases prosecuted under the False Claims Act. So promoting devices outside the use, that's a risk from a False Claims Act perspective. All right, next one is Assertio. So this is a drug company. They have a fentanyl nose spray called Lozanda. So they ended up paying, this was a qui tam case. It was two former sales reps, I believe. And this was just recently announced this month. They ended up settling for $3.6 million, but the key allegations were around practice development and targeting high-volume prescribers with their marketing efforts, so kind of strategically marketing certain high-volume in their area. And then they also did add that some of the customers were actually flagged for diversion or indicted, so there might have been something else going on, but this didn't cover those. This is an opioid, so it's kind of, taken with a grain of salt, but they essentially the settlement allegations were related to marketing, promoting off-label use. So the drug was approved only for breakthrough cancer pain and a certain population of people that were opioid tolerant and still needed some pain relief. And the allegations are that the company had kind of engaged in this program to increase the prescribing of off-label Lozanda. So again, takeaways. I should mention too, this also involved speaker programs and advisory boards. So they were selecting their high-volume prescribers to be on these boards. And again, focusing kind of practice development on those high-volume prescribers. Takeaways, again, off-label marketing, especially for opioids. I think we've seen kind of a definitely higher level of scrutiny being applied. So when there's patient safety or public health risk, there's going to be higher scrutiny. All right, Prometheus. So this was actually a DOJ-led investigation, so not a qui tam. It was announced in March. Prometheus is a medical device company. They manufacture pelvic floor therapy systems that require rectal pressure sensors and catheters. So they help with urinary and fecal incontinence. And these components, so they have kind of a system that they use for rehab. And the components were FDA cleared as either single use or single use only, meaning that they shouldn't be reused. However, the government has alleged that for a period of time, the company encouraged healthcare providers to reuse the devices by placing condoms or gloves over the catheters and the sensors to reduce costs. And I mean, in the IFU, it was sprinkled all throughout, like single use only, biohazard, do not reuse, but they allegedly were encouraging the use, multiple use, which is a little disturbing. And because that would result in lower overhead they wouldn't have to buy as many. And then Medicare was then billed for these treatments, so that's where the False Claims Act liability comes into play. Again, safety, when there's a safety issue, that's always gonna, again, get higher scrutiny from the DOJ. And here, clearly, there is a patient safety risk here. These devices are not intended to be used for multiple patients. That's a biohazard. So we'll just continue to kind of see, we continue to see safety cases where the patient safety is at issue to be on the chopping block, so to speak. All right, and then I will pass it over to Katy. Oh, geez, we have 5 minutes left. Pass it over to Katy for emerging False Claims Act risks.
Perfect, and I will be short and sweet on these. So high level, we are seeing additional scrutiny related to both genetic testing and telehealth. So in this context, we have 2 entities, GenX and Emerge, and also 2 executives who have agreed to pay $6 million to settle FCA claims over kickback-tainted genetic tests. So the allegations include the two entities, GenX and Emerge, which are Emerge being the parent company, as well as their CEO and COO, were accused of orchestrating a scheme where claims were submitted to Medicare for genetic testing that was collected by non-medical individuals in a non-medical setting, sometimes shopping malls or community centers. The samples were then sent in and prescriptions were obtained after the fact. In this context, the genetic testing was related to cancer genomic and pharmacogenic tests that were deemed medically unnecessary. Further compounding the issue, they're billing Medicare over $6,000 for these tests where patients were essentially asked in a shopping mall if they would be interested in the genetic testing.
That's right.
So in this context, the defendants agreed to pay $6 million. Additionally, for whistleblowers who brought the fraudulent activities to light were awarded $1.3 million. So again, another key TAM case, underscoring the importance of vigilance in healthcare billing practices. And our takeaways here are, DOJ is focusing on genetic testing fraud and telehealth abuse, particularly post-COVID. We want to make sure that these areas where there are more opportunities for abuse are being controlled and reviewed. Compliance risks for labs and marketers using commission-based models are also an issue. In this context, Emerge was the marketing entity, and GenX was being paid a portion of the proceeds from each bill submitted to Medicare. And then we have a Medicare Advantage in focus. So in this case, the allegations include entities such as Aetna, Humana, and Anthem paid disguised kickbacks to brokers of health insurance to push seniors to higher paying MA plans while claiming to be unbiased. So in this context, DOJ is stating that these brokers are intended to be neutral and help Medicare beneficiaries find the plan that works best for them. And they were creating methods to push patients to higher paying MA plans, and also working with these entities to push patients with disabilities to specific plans or not enroll them at all. So there is also a component here of discrimination related to those individuals' disabilities in an effort to keep costs down for the healthcare entities or the insurance entities. So we have false certifications in these MA contracts. We have CMS discrimination rules at issue as well. Why this matters is because we can see DOJ intensifying focus on Medicare Advantage in addition to traditional Medicare programs. This case bridges AKS, False Claims Act, and also civil rights enforcement. Again, another key TAM case in May of 2025. This litigation is still ongoing, but again, further pushing to ensure that we have compliant billing and coding for our.
I do want to mention the quotes from the emails.
Yes.
They're juicy. So in the press release, they had noted specifically and gave a few quotes, but there were some internal emails showing that they were aware of the non-compliance. This payment model is not even a little compliant, was one of them. And then the other one was, CMS will never figure that one out.
Yep.
Luckily, the government are generally morons. Like, who writes that down?
Executives joked in emails about CMS being too dumb.
Yeah.
Yeah.
Like,
So
okay, they need some write it right training.
Yes.
But anyways.
A side takeaway.
Yeah.
Right smart training is
Don't
also.
put that stuff in writing. With that, I know we're right at time. I'm not gonna, this is kind of a summary of everything we've talked about. I wanted to leave a minute or two for questions. Otherwise, we will be around for the rest of the afternoon if you want to catch us and chat later. Happy to do that. Any questions? We don't have any questions. All right, good. Well, thank you guys.
Thank you.
Okay, so I apologize to our virtual attendees. I'm being told that we have a little bit of a blurriness issue, so I'd like to ask the attendees that are here, if you happen to be on the Surly Visitor Network, if you could go off of it, that would help our virtual attendees so that it's not blurry. So thank you so much.
All right, thank you, Amanda and Brynn. That was Amanda and Katy. That was really good. Appreciate your thoughts. The right at right is always a good reminder of what not to put in. We don't have anything that jarring as an example, but certainly we have some tapping into FDA, some regulatory hot topics. We're focused today on FDA, a changing FDA. I have Brynn and Rebecca with me, and I'll introduce ourselves shortly, but we're really excited to have a conversation about how we approach FDA and what we've seen. So I'm Nate Downing. I'm a managing attorney with Gardner. I've been here about 4 years. I advise clients on a variety of FDA, some compliance considerations, anything from product development, submission, advertising, promotional work, and all the issues that come with that.
Hello, I'm Rebecca Zadaka. I'm an associate attorney at Gardner Law. I've been here for a little over 2 years. I work primarily in the regulatory group, mainly supporting some ad promo, but I also help out with some clients' matters as well.
And I'm Brynn Stanley, and I've been with Gardner Law for about 5 years now. I work in the regulatory group, and I focus mainly on regulatory and quality. And I do a lot of clinical trial work as well. So,
thank you. So we are going to have time at the end for questions. So if you have any questions, feel free. But like Amanda said, we are going to be around, so feel free to grab us. But today we're focused on a changing FDA and some types of changes, right, that you'll see in some conversations we'll have. One of them being staffing changes, right? That's been pretty prominent in the news. Staffing changes, who's been let go, who's been brought back, what are the impacts? I'll give a quick kind of my own experience from even this morning. I was on a call with FDA. It was part of a submission issue, so an SIR meeting. And typically, I know it says you get to choose either feedback or written feedback, or either a meeting or written feedback. And it's oftentimes you'll get both, right? I think it better prepares the meeting. It sets the stage. We got on the call with FDA, and we noted, hey, we did not actually receive anything. And they were like, well, we didn't have time. And it was actually impactful to the meeting because the issues they wanted to discuss were different than those that we had prepared for, essentially. And so there was a impact to the meeting today. And I think that that's also kind of a ongoing theme, right? I haven't really seen great misses on MDUFA, but some of the more quote-unquote optional touch points may be going away due to some of the staffing issues. And as an industry partner, right, those are amazing opportunities for us to get in front of FDA, and losing those, I think, hurts FDA efficiency, not helps FDA efficiency. So, that's just kind of one story among many, but that's part of the thread, a theme that we'll be threading through policy updates, right? There's still a lot to come. There's been a lot of executive orders, other documents about regulation, reducing regulation, deregulation. So what does that mean? Brynn's going to get into some of that. But just kind of a high-level overview of there are policy updates coming. There may be some already that you've seen, but it's a way to keep watching, and you need to keep aware of what those might be. Enforcement pursuits. Enforcement is always an area of everyone's concern, right? It creates a lot of time and money. Even if that enforcement turns out in your favor, it's still an impact. And so inspections, Brynn's going to get into that. Advertising, Rebecca will touch on that, of what might this current FDA administration do. And then enforcement light. I see a lot of times where FDA will kind of reach out, and to them it's informal. Like I call it enforcement light. They're not really mandating something because they can't per their process. They haven't done enough to do so, but it's still disruptive, and it's a way for them to try to get a message across. And so as industry, really making sure we hold FDA to, they have standards. If they want to take action, they need to meet those standards. And so kind of paying attention. Might there be different types of enforcement light, as I call it, that comes through, and maybe that thread will come out. So before I really get into it with Rebecca and Brynn, thinking about how to approach a changing FDA, your overall approach and your regulatory strategy, right? You have to think about your inability to maybe have some of these unofficial touch points, right? The timing. Could there be impacts to timing as staffing reductions make more of an impact given the time from when maybe a lot of submissions were already in process? And so keeping an eye on that. Maintaining audit readiness. Foreign inspections. I think Brynn is really going to give us some great insight into that. And so understanding that just because some staff has been let go, it doesn't mean they're not going to be showing up or showing up virtually. Promotional material, having a keen eye, understanding what this administration under the HHS secretary, what they might focus on, right? And so, having a buttoned up area in your promotional review and making sure you understand the risk properly and are, attending to those risks. And finally, adapting to FDA. Part of this conversation will be, hey, here's some things that are coming. And the bottom line is you need to be adaptive, right? Our goal is to get on market, to be compliant, and understanding what FDA is going to do before it actually impacts us is important to being able to adapt. And so getting kicked off, I want to first turn to Rebecca. There's been some proposed changes to GRAS and food ingredient regulation. Currently, if a food ingredient is added to food, it's food additive unless it's considered generally recognized as safe or GRAS. And so, Rebecca, tell us how this system works and a little bit more about what's going on.
Yeah, so this whole GRAS system has actually been around for quite a while, but a lot of consumers don't actually realize how these food ingredients are regulated. So as Nate said, food ingredients, if it's added to food, is considered to be a food additive unless it can fit one of these kind of carve-out definitions. One of them is GRAS, or generally recognized as safe. And these GRAS ingredients, they include some ingredients, that have been on the market pre-1958. Think like sodium nitrate in luncheon meats. Those have been around a long time. We know them to be safe. But what about a new ingredient that we think is generally recognized as safe as well? So some of these ingredients like carrageenan is considered one of the newer GRAS ingredients. The way it works essentially is a manufacturer can essentially self-determine, it's called a self-affirmation process. They can decide on their own that an ingredient is generally recognized as safe. They are supposed to, use public data, qualified experts. It's supposed to be public knowledge that it is generally recognized as safe. And they have an optional way to notify FDA. FDA can question it, say they don't agree, but this is all optional. So a lot of manufacturers will just do this self-affirmation process. And later, if FDA does question an ingredient, they have been known to say, actually, we don't think so. For example, Terra flour is an ingredient that was determined to be GRAS, and FDA later said, actually, the data doesn't support this. And so it was removed from that designation. So there are some benefits to the system in that, if manufacturers are doing things the way they should be, in theory, there's a lot of opportunity for innovation, get new food ingredients out there. There's a lot of new plant-based meats. They've come on the market quickly. If they did have to go through FDA approval, that would obviously slow down this innovative process. But there are, some question marks here. There isn't always a good lack of transparency. There could be some conflicts of interest here. So there have been some proposed changes to this system. There's nothing solid as of yet, but some of the proposals have centered around making this optional notification process no longer optional. So that would mean manufacturers would always have to basically tell FDA, here's our new ingredient, we think it's GRAS, here's why. And then FDA would have to review all of them and say yes or no, essentially. There haven't been any, suggestions as to how FDA would staff this. That would be a significant increase in review that FDA would need to take on, as Nate was alluding to, how would this work? We don't know yet. There's still a lot up in the air, but that's a potential to happen in the near future.
Thank you, Rebecca. So now I'm going to turn to Brynn, and this is something, too, that's really been in the news quite a bit on FDA inspections. The FDA is intensifying unannounced foreign inspection efforts, despite even the recent staffing reductions. Manufacturers are advised to improve their global readiness by strengthening their compliance through mock inspections, updating trading protocols, and review of documentation and quality management systems. Brynn, what operational changes can you manufacturers implement now to reduce the risk during these FDA's expanded foreign inspections?
Yeah, so, and before I jump to answering the question, just a little background. Some of this started during the COVID-19 pandemic. The FDA was noticing, or previously foreign inspections, manufacturers were getting more notice for inspections versus domestic manufacturers, which typically would see the unannounced inspection. So there was a little bit of a unfair advantage is what kind of some of the thought process was behind that. And then some of the COVID-19 pandemic disruptions and inspections, there's just been a backlog. So part of why this is coming on now is to clear up some of that and then also kind of level the playing field. So what manufacturers should be doing now, and it is something that manufacturers should always be doing, which is making sure they have running a compliant manufacturing facility. But what we are encouraging manufacturers to do is to take a look at for domestic manufacturers, take a look at their supply chain and see kind of, if they have foreign manufacturers also involved, because they might be impacted by these inspections as well. So this isn't just isolated to foreign manufacturers, but aside from that, so clearing up your supply chain, making sure you're doing those supplier audits, making sure your foreign suppliers are ready. From a foreign manufacturer standpoint, what you should be doing is taking a look through all your records, doing mock inspections, planning your facility for a FDA auditor to show up, or inspector rather. So it is part of a compliant quality management system to have your internal audit procedures ready, but it is often sometimes one of the more overlooked portions of folks' operations. So we are kind of emphasizing that manufacturers should really step that up and make sure that their internal audits are on time and have been implemented, and any corrective actions that they needed to put in place have taken place. So we might see the FDA, you might see them anytime. So I really do think this is one of those areas they are going to emphasize. So
Yeah, thank you, Brynn. I mean, it's an area too where when it happens, if it goes well, you feel great.
Yep.
You're flying high. If it goes poorly, major impacts to business, major impacts to a lot of the ways you move
Yes.
forward. So an important area to be aware of. So now we're going to move into some questions to Rebecca again about ad promo updates. And I think something recently interesting that happened that Rebecca will touch in, but to me, I'm in a lot of meetings, and maybe a marketing VP is putting together an HCP facing piece. And it's kind of like, well, what's the risk, right? I mean, that's the question I get a lot. And it's not my favorite question, because I usually say, well, the risk of what? Getting caught? Because you're not complying, I don't give you the risk of getting caught. But it is interesting to see some recent development on where maybe FDA is starting to go as well. So despite all the recent changes at FDA, there have still been 3 untitled letters in 2025. Rebecca, what has FDA enforcement looked like recently related to the warning or entitled letters?
Yeah, so as Nate just touched upon, they're still active. There have been 3 untitled letters so far in 2025, and what's interesting is they've been on a variety of materials. As Nate alluded to, one was actually a speaker deck presentation that was aimed at a healthcare professional or HCP audience. Another was the efficacy page on a website for another drug, and another was actually an exhibit booth panel. So all sorts of areas that FDA is looking into. And, it is a little bit less common that FDA would go after something that is HCP facing. Typically, they're more concerned with the consumer material, because consumers could be a little more easily misled. They don't always have all the right background material or context to analyze claims from. So this one was a little bit of an interesting letter. It was pretty long compared to other letters, and it appeared, that FDA, this was not their first time to let this manufacturer know of some issues they had with some of their claims and marketing material. To add insult to injury, this was a black box warning drug, meaning it does have higher risks to consumers. The letter called out several times where there were claims that the active ingredient was superior to others on the market when the data that was cited didn't actually support this. Risks were mitigated, efficacy was overplayed. All the while, they had loads of citations for all of these claims, but FDA really dove into them and said, no, this data does not support this claim. And the reason I think it's so important that FDA did this is because an HCP who is receiving this information and they can see, oh, look, there's citations, they're more likely to just believe it, even if they say, hey, this claim actually contradicts with the PI, that's the prescribing information, that's interesting, the manufacturer's telling me this. And so they might prescribe the drug to a patient that's not appropriate or increases risk to patients. So it's really important that they are speaking accurately to these HCPs. So FDA is really looking at all of that, and it's different and it's important, and you need to be ready for any material to potentially come under target from FDA. So far we've seen in 2025, all types of material have been targeted. Something I do expect, I don't know for sure, but judging off of 2024, there were a couple of untitled letters relating to material that was on social media. I would not be surprised if we saw more this year on that, considering a lot of manufacturers are now putting different material on social media like LinkedIn. That is actually a kind of a little bit of a more dangerous place given the nature of social media. There isn't as much space or time to put everything that you would normally put with some sort of marketing material. There are a lot of other people looking at it. I've seen several, companies write complaint letters to other companies or to FDA for material that stems from something on social media such as LinkedIn. So it is important to make sure all of your material is always compliant. Don't assume FDA is not looking, because if they're not, a competitor might.
Yeah, thank you, Rebecca. Ad promo is such a important area from a company standpoint, right? This is how you promote your product, but it's where everything is seen by whomever, competitors, FDA. It's very permanent, right? We have programs embedded in our quality systems to claw back material that may be non-compliant, but we all know once it's out there, it's out there. So making sure that first pass is thorough and you've got the right eyes on it is important. So now we're going to move to something that's really, in this administration, a hot topic. And I think, it's things that can sound good to industry, but also can be a little scary to industry. So we're going to move on to deregulation. And I'm going to ask Brynn about this. So HHS and the FDA issued a request for information seeking public input on which regulations could be modified or eliminated to lower healthcare costs and reduce administrative burdens. Under the directive, HHS must eliminate 10 regulations for every new one, reduce overall regulatory costs below zero in FY 2025, and broaden oversight to include informal policies and publish annual reports to enhance transparency. Brynn, what are the potential impacts that this may have on manufacturers?
Yeah, so as Nate was mentioning, this administration has this is one of the things that they're emphasizing to really kind of cut the red tape, I think is one of the quotes that was put out there. And this was, Trump had an executive order similar to this in his first term, but it was a 2-for-1. So this is really kind of driving it home. So now it's, instead of getting rid of 2 regulations, we're getting rid of 10 for every new one added. So it's kind of the first administration's executive order, and then I guess literally turned up to 10. So, but what the thing that can really impact manufacturers here, there's kind of a variety of things, but mainly it's kind of be flexible. You really should have kind of your regulatory team taking a look constantly, I guess, at the FDA for updates. There might be a lot of changes coming through. It's kind of really difficult to tell right now. An important piece about this is that manufacturers do have a little bit of say. So I do encourage manufacturers to go in, make those comments during this public comment period. I believe there's 60 days, and I believe it started May 13th. So there's still time to go in there and make those comments. I know that, I have worked for manufacturers in the past, and I know there are a lot of certain regulations that a lot of them just would rather not follow. And some of them are really overly burdensome. So this is the opportunity for manufacturers to really kind of potentially influence that and make things more streamlined for those types of regulations that just aren't necessary. The other piece, what was I gonna shift on? As kind of these changes start rolling out, the other piece is to just watch out for those new regulations and make sure that you are staying compliant with those as they come rolling out. So there might be new guidances, new regulations. It's not exactly clear what the 1 for 10 rule means. How are we defining what 1 for 10 is? So I think it's just a good opportunity to be flexible and be optimistic, as we do have opportunity. There is an opportunity for the public manufacturers to kind of drive some of these processes.
Yeah, thanks, Brynn. And, I think it's important too, as Brynn was alluding to, like regulation, it's the world we live in, right? And so sometimes, regulations can be annoying, but they also can provide predictability. And so you have to think about, are you able to follow this? Can you meet it? Is it a standard? What happens to competitors if I'm already able to meet something and I just, maybe whatever reason is, I try to advocate to remove a regulation, and now it opens up the floodgates for others who didn't meet the standard that I met, right? And so, regulation's good and bad. And the point of me saying this is kind of the eye that I would take to this is, okay, is this truly a burdensome regulation? If so, is there any benefit to? Is there ways to shape it instead of remove it? May not always fit the 10-to-1, but there's going to be a lot of kind of back and forth. And this is the time to get those comments out and be heard. So I appreciate Brynn for that message. So we're going to go back to advertising because, as you read, this is where a lot of companies stumble. It's where when you get a letter from FDA, whether it's come to our attention, it's entitled, it's more, or I've seen it where FDA simply asks a question to a regulatory leader at a company and says, hey, can you tell me more about that claim? The wheels start turning at a company. The money starts getting spent to respond, and the resources start being utilized to make sure that things are up to date. So it's a really important, really high gain, but high loss area. And so we're going to turn back to Rebecca for another kind of question on direct-to-consumer, DTC advertising. So Secretary RFK has suggested banning direct-to-consumer pharmaceutical ads from TV, which has sparked some debate. What are the main reasons for supporting this ban, Rebecca?
Yeah, thanks, Nate. And, this kind of factors into what we were talking about a little earlier with the HCP deck. So FDA is, concerned, and there are other people who are concerned about the potentially misleading nature of advertising to consumers. We've all, seen these pharmaceutical ads on TV sometimes. Some are, a little more out there than others. We're all aware of, these ads, and then they mention all these risks at the end. And the idea is that consumers are going to be involved in their healthcare. They can see these ads and say, like, oh, I think this might apply to me. Talk to their doctor. There are risks of it. RFK has mentioned he's worried about overprescribing. Maybe a consumer hears this drug and then goes and talks to their doctor, and their doctor is a little more inclined to prescribe this drug because the consumer wants it, and they're, all right, your patient wants it, but maybe that isn't the initial path they might have taken, but now they're kind of influenced, or they might change the direction. Ideally, they wouldn't, but who knows, that it could happen. It's, data has shown that pharmaceutical industry's rate of return on these ads is actually tremendous. It's a very good economic situation for them. It would certainly be harmful to them to no longer be able to advertise direct to consumer on TV. It could be really difficult to do a ban. I mean, there was recent a case surrounding putting the wholesale price of drugs on TV ads, and it was struck down. There was a First Amendment claim to commercial speech in there that the court did not address. Ultimately, they said there wasn't authority to have that wholesale acquisition price on these ads. So there could be a lot of hurdles to banning it. I think what's more likely is maybe we'll see a little more restrictions, a little more regulation, maybe acting with the deregulation, who knows. But it certainly is brought to the table that this could be problematic. So only time will tell what will happen with that, but it could be a difficult one to implement.
Thank you. Quick comment on that, direct-to-consumer advertising is unique in the U.S., but it's also important, right? There's a lot of litigation from a malpractice standpoint. And so in a lot of ways, patients advocate for themselves, right? Oftentimes you'll hear a physician say, well, you choose the path, right? Like, what do you want to do? And so there is a lot of message that gets out. And so also that's why the U.S. is such a unique space in that we've got a lot of DTC advertising, but we also have a lot of patient advocacy. And so, there's an offset there, and right, we'll see where everyone settles, but it's certainly something to keep an eye on, to more reason just to keep that direct-to-consumer advertising, closely reviewed and compliant. So we got one last question that I want to ask Brynn, and this is something recent that's come up, but also a very interesting FDA hot topic. AI-assisted scientific review pilot. So, Brynn, earlier this month, the FDA announced completion of its first pilot using AI, or artificial intelligence, to assist in scientific review. The agency plans an aggressive expansion of AI use across all FDA centers, really in the end of the next month, by June 30th, 2025. How might this change the review process?
So I did want to just lead with, if I would have given this presentation a month ago when this came out, it would have been a very different presentation. I was very much an AI skeptic. I know it's wrong a lot of the time, and I was like, this is going to be a disaster. I do think that it is not nearly as disastrous now that I've kind of looked into this a little bit more, and I've used AI more myself just to kind of get a better feel for it. But so I think that there are potential downfalls for it, but I think that it's not necessarily going to be the disaster I first thought it was. So it does still feel like a pretty aggressive timeline. By the end of June, it's going to be across all centers. So manufacturers do need to prepare starting now, especially if they have submissions coming up. Kind of the main thing for manufacturers to consider is AI is going to be kind of the first set of eyes, so to speak, on their submissions. So you need to kind of develop your submissions in a way that is machine learnable. So knowing that it's going to be in there, making sure all your tables are formatted appropriately, that your wording is consistent, just kind of any of the tools that you would normally use to kind of teach your own AI when you're kind of doing your own searches. Make sure that you're kind of keeping that in mind as you're developing your submissions, just to make sure that it's not getting flagged for something kind of silly whereas it normally, a human probably would have caught that. But that being said, knowing that there are some staffing shortages at the FDA, I did have AI actually develop a little pros and cons list just to kind of end this piece. So the pros are that it can speed up the scientific data review, and I think I agree with that. That makes sense. Enhance consistency and reduces human error. Yes. Frees up reviewers' time. And that is one of the frees up the reviewers' time is one of the pieces that the FDA has enforced as part of their announcement. And then improve scalability. So that might be a bonus for manufacturers. We might be able to get through these things faster. The cons are requiring sponsors to submit highly structured, machine-readable data, which we talked about. Introducing concerns about transparency and interpretability of AI tools, and the initial adjustment period needed for reviewers and sponsors. So I think I agree with all those, and I think AI might be right on those too. So.
All right, thank you, Brynn. Time for a couple of questions just in closing. Some key takeaways. First, AI has Brynn's stamp of approval, so that is important. Congrats to AI. But remember, FDA is changing right now, and you really need to be aware and adaptive. And because some of the changing isn't something that I can foresee right now, right? You don't always know the impacts, like I said this morning, of a meeting where the interaction with FDA was slightly different than it would have been a year ago. And so accounting for that, trying to reach out earlier, trying to do different things to offset some things that may have been lost, but also take advantage of the opportunities. The deregulation is a really important industry aspect that if we can take advantage and you can make some change that better still protects the public but gets your device out or allows you a better, more clear path to market, that's an important change. So in the next 50 days or whatever is left, taking advantage of that comment period. But, making sure no matter what, you pay attention to FDA and you be adaptive as industry and continue to try to partner with FDA as best you can is extremely important. So we have 3 seconds, so if there's any questions, happy to take them. All right, thank you. We're going to take got an in question. Let me bring a microphone to you.
Hi, I had 2 questions, but I'll just start with one because I think it was almost partially answered with the AI-assisted scientific review pilot. So it sounds like the FDA is trying to leverage AI in order to expand efficiency and reduce their staffing, because my concern was that with less staff, how can the FDA actually do the work that they need to do? So do you see the FDA in the future, hopefully, kind of getting back to the status quo of the amount of work they're able to do with less staff because they will be AI assisted in the future?
I think it could really go either way. So if they're short-staffed and now we're flooding them with submissions, yes, we can get through that initial period, but now we have a backlog. So I feel like it probably will eventually balance out, and they may, depending, I guess, on what happens and how this pilot rolls out, it could even go the other way where they start needing to hiring staff back because we are quicker now. But we probably won't be quicker on the human part. That's probably still necessary.
That makes sense. And really quickly, my last question, the request for information. So my sense is in the past, the FDA would ask for this from the public, but not really act upon it. I'm not sure if that's due to potential previous administrations, maybe not having the same focus on efficiency and monetary efficiency, I guess, as this administration. Do you see a significant difference where there may be acting more upon public comment based on?
Yeah, I do think that that's the opportunity why it's so highlighted is there's an opportunity that FDA will act upon some of this. I'll come grab the microphone from you. And so because of this administration's kind of open willingness to deregulate, if you will, I think this is a key for them to find regulations that industry can be happy, and it's obviously much easier to push through certain deregulations when you have an industry partner who's advocating for it.
I have a quick question. Did the FDA provide any assurances around where the data are going? Is it like walled off from the world, or I don't know, like if you're a device maker or a drug maker, is there some sort of assurance that your data isn't going to find its way into the public domain once you put it into the machine?
I couldn't actually find any information really on exactly what the AI was doing, which is, that's where the Brynn skeptic comes in. But I couldn't find information necessarily like on how they were validating the program, what they did exactly. Just information on this announcement is pretty much all I could find so far. So.
Thank you. We are going to turn it over to David.
Thank you. Right, left, up or down? Okay. All right, I'll get started. And my introduction is the good news is that I have lots of experience doing what I'm going to talk about. The bad news is that means I'm senior counsel. So that's one of the good news and bad news. So this is a cartoon that my partner a long time ago and mentor would use almost before every presentation he did. So I had to haul it out for this since I have some good news and some bad news. Hopefully, even though we're going to be talking about product liability, sort of litigation themes, you'll see how they connect, and I will try to connect them to some of the things that were just discussed, especially as it relates to direct-to-consumer advertising in general, and regulation. What kind of regulation system, if it's going to change, what kind of regulation system we want. But we're going to go from the specific to the general, and if I don't make all the connections, ask me afterwards and we'll try to make them for you. So the agenda is this, not necessarily in that order. We're going to talk about how litigation's being brought and funded, how the focus has changed, and then some of the specific rules within how evidence is presented and or accepted or not accepted by courts to prove cases. All those things will hopefully never be part of your life, but could be because product liability litigation, whether it be about warnings or manufacturing defect, even though those are fairly rare, or design defect, always happen, and it seems like it's hard to be spared from that world. In any event, so by the way, I'm not focusing on healthcare and anti-kickback trends because my colleagues did a brilliant job in the first half hour, and I don't have enough time, so there's no reason for me to do that. So the first case I'm going to talk about in the first general category of cases is no injury consumer protection cases. So one of the things that I do in litigation is class action food cases where, and you've probably seen news about them, there's something in my food that I didn't like. You told me it wasn't there by saying it's natural or whatever else it is. And so the value of the food I purchased wasn't worth what I paid. It's that simple. I would have paid $1. Instead, I paid $1, instead it's worth 95 cents. Multiply that by however many consumers in a particular state. then you get damages that plaintiffs are worth chasing. In this particular case, it relates to antifungal medication, so it's a over-the-counter medication, and there's no allegation of injury. So it makes these unique. Since there's no allegation of injury, there's less proof burdens for the plaintiff, right? They don't need as many experts about how the device works. They don't need experts about what the physicians are thinking or what the standard of care is or any of that stuff. It's this medication had, and in this case, had benzene in it, and it was actually recalled in this case. So in some cases, there's a recall that triggers the litigation. In others, it's somebody finds out by looking at labels or testing. So there are testing labs that plaintiff's counsel uses with food, medical devices, or whatever it happens to be to find out what's in it. The larger context, I'm really backing up here a minute, is that things that are in our food and products are obviously being highlighted right now by this administration. So that's why this case kind of fits into one of the themes that our previous panel was talking about, because that's going to be a focus. You think, well, no, they're talking about the additives in Fruit Loops. No, I don't think so. They're talking about vaccines would be the next thing you think of. But I think that's going to be a focus for other products, maybe not so much in implantable products or other products that you make, but it'll still be an important theme. So anyway, in this case, the claim is simply that, so this is part of the bad news. The claim is that there was benzene in the product, therefore I'm suing you and on behalf of every consumer, so you have a class action representative, on behalf of every consumer to get back what I should have gotten. So I paid $1. I think it's only worth 90 cents because it had benzene in it. And so we're going to sue that case out and mete out this money to all the consumers who fill out a card. You may have gotten them in the mail, right, for being part of class actions, whether it's your some 401k fund or whatever. You fill it in and send it in, you get some money back. So not normally the province of medicines and medical devices, but increasingly becoming part. And unfortunately, in this case, the court said, yep, there was an economic loss. The medicine did not have the same value as it would have without benzene. So there's a loss. And it doesn't matter if consumers don't have to prove that their particular tube or bottle or whatever of medication has benzene in it. So that's not a great result, right? Because the level of proof is small, right? Because we know you just have to convince and these rarely get tried, you just have to convince the finder of fact, the jury, that, and when you have an FDA recall, right, it's not going to be too hard to convince a jury that, well, it's like there's and it's a 51% proof, right? It's a probability that that the product had benzene, so you win. So that is a trend that's continuing, and that is part of the bad news, unfortunately. So preemption, some good news. Preemption is a concept that comes from the Constitutional Supremacy Clause that said if the federal government makes laws that conflict with or are predominant in a field of law, then that law is the law of the land. It's called the Supremacy Clause. And generally, it needs to be expressed. So there's a statute that says this statute expressly preempts all state laws related. So any state laws that create different or more onerous regulations would be preempted by federal law. So you find it in the labeling laws of devices and food where there's express preemption, but not in every law is there a express preemption provision. So you have to rely on field preemption. Well, this case was a case of a chemotherapy drug, docetaxel, and it treats cancer, obviously. And there was a side effect of alopecia, and that wasn't in the warning. And this particular device was approved by the successor statute to what we used to call paper NDAs. And but the court said, you know, you didn't have enough evidence to show that that warning would have even been accepted or needed to be considered under the regulations relating to changing your warnings, which is the change being affected regulations. So in that case, the court determined that the federal regulations preempted any state requirements that there would be. And usually the state requirements, I should back up, are consumer protection laws. They're not specific state requirements relating to labeling of drugs, right? Most states don't have. They have specific regulations specific to medicines or devices, but they do have consumer protection statutes that say that everything has to be truthful, it can't be fraudulent, et cetera, et cetera. So that's the importance of this case. And there aren't many cases that establish preemption for a kind of a new category of devices or medicines, and that's why this case is important. But it also raises another question. We were talking about deregulation before. So if deregulation occurs in the space of medical device and drugs, or food for that matter, what might fill it in the absence of express preemption might be disparate and maybe not, and maybe more onerous, or maybe not at all, state regulation. So also part of the calculus in deregulation at the federal level is what might the states do who are more concerned about protecting their citizens than the federal government. So do you end up then with a series of federal or state regulations that aren't consistent, maybe more difficult to comply with? So another thing to consider when making commentary about deregulation as invited by the White House, and that's how the preemption conversation hopefully relates back to general regulation of medical devices and drugs. All right. So the next one is the learned intermediary doctrine. And, well, why do we care? Well, we care because science matters. And because science matters, we need people that know the science in order to defend or prosecute cases related to medical devices. And it also matters because of direct-to-consumer advertising, which we just talked about. So more and more plaintiffs might be empowered, and it's probably good generally. I mean, that's the whole idea of direct-to-consumer advertising. It's not just a profit-generating machine, it's also an information-imparting machine. So and we'll talk about this in a few minutes, but there's a First Amendment element to that conversation that'll have to be taken in consideration before we start banning advertising to consumers, as long as the advertising otherwise is truthful and not misleading. In any event, the learned intermediary doctrine is particularly important for medical devices and drugs because the doctor's the gatekeeper, right? The doctor decides what you get and why you get it and how it's supposed to be treated and how therapy is supposed to work. And the plaintiff can say yes or no, but the warnings go to the doctor. They don't go to the patient. Now they do in advertisements because we hear the end of every advertisement about warnings. In this case, it had to do with electrocompulsive therapy and the chance of brain damage or memory loss as a result of it. And one of the good parts of this case is the California court. You'll notice that the California cases that are the cases that are problematic for the industry, California, good for the industry, Texas. But that's not hard to understand. But in this case, the Supreme Court said, yeah, the learned intermediary doctrine absolutely applies, and it's not a defense that the defendant has to prove. It just is. It's a concept. There's no issue about that. The bad part of the case is that they said that, so the plaintiff's argument was, well, if I think I would have said no, right, to the treatment. If I'd have known about the warning, that's all I need to show, right? I'm a reasonable person. If that my doctor would have been told about that warning, and the doctor would have told me, and I would have had the choice to say no. Well, that's a great standard if you're buying cereal or something else. But for medical devices, the judge said, no. It can't be that easy, right? You have to be able to, the doctor is part of, if not the main part of deciding the safety of therapy, whether it be a device or a drug. But the court came up with a kind of a compromise concept that said the plaintiff only has to prove that the doctor would have communicated the warning had the doctor received it. So if the doctor got a change of label from the manufacturer and it said, yeah, you got this warning's being added to the label, in this case it'd be memory loss or brain damage, although might anticipate it if you're getting electroshock therapy, but and was probably discussed. Of course, that's the problem with these cases. They never tell you exactly what was discussed in the room. But in any event, the court said all the plaintiff has to show that the doctor would have communicated the stronger warning. Of course, that's kind of hard because you got to, the doctor is going to say, I don't know, right? Depends on the warning and the wording of the warning. Depends on the data. I mean, the doctors aren't completely ignoring what's going out in the field, right? You're not just handing them, take my word for it, give it to this guy, right? So that's a kind of a high standard, not as high as we think it should be. And the second part of the test, you have to show that a reasonable patient under these circumstances would have declined the treatment had they known the warning. So it's a little bit of a win and a little bit of a lose, but generally, for the court from which it came, it's pretty good news. And just so you understand why I picked this particular case and the consumer fraud cases, for lack of a better description, is the plaintiffs are trying to avoid what has gotten better for defense over the years, and that is the high levels of proof and the high levels of expertise they need to prosecute their cases. So by chiseling away at learned intermediary doctrine and other standards of proof, it becomes, for some reason there we go. So now even more obscure, Rule 702 of the Rules of Evidence. So this relates to experts, right? So in prosecuting, defending cases, you have to have experts usually, especially in this medical device and drug cases. So we find experts. Either they're people that we work with, physicians that have been advocates of our therapy, or they were researchers on the therapy, and those are the defense experts. And then the plaintiff finds experts. Always harder because they're not necessarily connected into the people that know as much as the manufacturers do. In any event, this case was a good case, and it related to a diabetes drug that caused, the allegation is that was causing heart failure. Excuse me. And in this case, an expert was proposed by the plaintiff, and the court, and that expert had not, it was one expert. And so what do you do to try to get rid of experts? You bring a motion to disqualify that expert. It's called a Daubert motion. If you get rid of the expert, you get rid of the case, generally. So that's why this is important. And the court said, well, that's great, plaintiffs, but your expert ignored contradictory studies. So actually, the court, those hearings are fascinating, they're interesting, and almost always the judges really care about hearing all the evidence. I've never been in a case where I've had a judge say, I don't care. The plaintiff's got an expert, happens though. Plaintiff has an expert, defense has an expert, jury will figure it out. It's all in. It's usually a pretty careful process. And in this case, the judge said, you didn't look at contrary studies. And the studies in which you did rely don't even relate to the injury. So the risks that you're bringing up in the case, they're risks maybe, but not the risks that are relevant here. So that's important. And then the rule was changed in 2023, the evidentiary rule, for the I think for the better, and that is it has to be a reliably applied methodology. You can have a person say, you know, I've done tests and things and I've researched the data and find a bunch of evidence that may be contradictory and damaging to the manufacturer's defense, but it wasn't based on good science. And so that's why reliably applied was added to the rule, and why it's an important in this case, or an important case in this matter. All right. First Amendment to the rescue. So in California, there's Proposition 65, and you might or might not know about it. You have to give warnings of the inclusion in your product of compounds that could cause cancer or have reproductive health risks. And that's an industry in California for some lawyers. They just send out Proposition 65 letters about products, doesn't matter if it's food, devices, garbage cans, hose, whatever it is. They don't, right? Somehow you haven't put the very prescribed warning on the label that needs to be on there as set out in the statute. One of the problems with Proposition 65, it was written with the language that studies from a lot of different places, World Health Organization, other countries, can be considered in whether the particular compound in question should be on the label. So it's not just what happened in the United States. It's kind of wide open, and it's a shall language. If there's studies from the WHO that show that some compound causes cancer, you shall put it on the list, or at least put it in the system to be determined whether it should be on the Proposition 65 list. Well, anyway, in this case, Proposition 65 was going to require, the state of California was going to require that acrylamide be put, there'd be a warning. Acrylamide is most known as a byproduct of heating, so coffee. So every cup of coffee has acrylamide, mostly, if it comes from roasted beans and whatever. Toast, right? If you eat toast, right? A Pop-Tart or whatever. So it's sort of, the industry's going, wait a minute. I mean, what's the evidence that the amounts of acrylamide that are in these products, or any of the products that are requiring the warning, are going to cause any harm? Also, it's not in the product when they buy it, right? It's in the product when they make it, right? Or if they cook it, or whatever the case may be. So what are we doing? Plus, the studies aren't conclusive. They're not, it's not a settled science about acrylamide. Its prevalence, what's the dose, and what's the impact. So the government, in this case, a federal court in California, which is not always that friendly about these issues, said, no. You can't make people say things under the First Amendment if it's untrue or controversial, right? We can't be compelling speech that otherwise is not healthy or otherwise is not true, because the whole point of the First Amendment, this, don't laugh, is for truthful information to be given to people so they can decide things. Now, in the current climate, that may be failing a little bit, but in any event, that's what happened. So this is an important case for labeling, not just labeling of food or other products, but as there is more and more focus on what's in our products and more questions asked. We were talking about grass before. Just because it was on the list in 1958 doesn't mean it's free. I mean, that you can use it. They're going to be reviewing all those, not all of them maybe not caffeine, but reviewing a lot of those food additives, not food additives in the technical legal sense, but things we put in our food that maybe think cause mental disorder in kids or whatever it is. So as that ratchets up and the government believes there's questions about the safety of those products, there may be a higher demand for warnings. And then the question will be, is there enough science to make people warn about something that seemingly has been safe for 55 or 60 years? And that's why the First Amendment will be important in the product chemistry, for lack of a better description, going forward. And is one of the reasons I highlighted this case is that trend in looking at what's in our environment and what we're ingesting and putting in us becomes highlighted. Finally, third-party funding. Sorry to end with bad news. But how did all this happen? How do the plaintiffs get the money to run all this up the flagpole, right? I mean, it's expensive to create class actions, and you're talking about cases that are difficult. You know, the proof is difficult, and gathering up plaintiffs, class representatives is difficult. How does this get, how does an individual firm in some state fund it, right? It's not free. Well, people are willing to help them fund it. And so a trend that's been going, it's not particularly new, but continues to be part of the landscape, and that is third-party funding of litigation. And there's no law that's going to change that. It's a right to contract. People can take the financial risk they want to take. I suppose, I don't think there could be constitutional legislation to outlaw it. I don't know for sure, but it seems like that is unlikely. And so if you're wondering why we constantly have people after the industry, it's become easier to find the financing to do it than it used to be because the risk is spread out. It's not just on an individual or an individual law firm or even a group of law firms in that case, which leaves 2 minutes. If anybody has any questions. If not, we're caught up. No? All right.
Thanks, David. So we're going to take a 15-minute break. Please feel free to help yourself to refreshments. Restrooms are down this hall, straight forward here. And feel free to stretch your legs. If you're attending virtually, we will be back at 1:45. Thank you. Can you get Charlie's attention? Okay. Okay, if I could have your attention, if you guys could all find your seat. So our next session will be with Paul Rothermel, hot or cold, a privacy enforcement update. Take it away, Paul.
All right. Hi, everyone. Good afternoon. Thanks for being here. I won't keep you too long. It'll be another quick 30-minute session talking about privacy and cybersecurity enforcement. Particularly in the US, we'll focus on that and as it relates to technology, especially in the medical space, but we'll discuss some other related enforcement activity. A little bit about me. My background is in privacy and cybersecurity, compliance, and I've been practicing at Gardner, focused on those areas as well as AI and technology. So we'll skip right past my bio and we'll get into this. So to kind of frame the discussion, I'm not going to dig deep into the legal standards. We're going to focus on what is the Federal Trade Commission, what is HHS, and the OIG looking at in terms of HIPAA enforcement. We'll look at a few states and how they're regulating and enforcing privacy regulations. And then we'll also take a quick look at some GDPR-related enforcement, particularly around med device, but also some of the broader trends that we're seeing in terms of enforcement. And I asked the question, hot or cold, to start off. I really think enforcement, maybe it's not hot at this point, but there's certainly some movement. I think clients ask us often, is this really being enforced? Is there really activity around this? Isn't it just the large organizations that are seeing enforcement? And I think the answer you'll find today is it is an active area, growingly active, especially in terms of state law enforcement. Whereas federally and internationally, it's already been a pretty active area. So let's start off with a HIPAA example. So generally speaking, HIPAA is a regulation that applies to what are called covered entities and their business associates. Through those laws, the government has the ability to bring actions through violations that are cybersecurity related, so failures to address security rule requirements and privacy rule requirements which relate more to the use of information and how certain rights are addressed for patients. So in these examples, and we'll start with this one from Warby Parker, there are various kinds of violations that are highlighted and cited by HHS in their enforcement activity. And then along with that, there's typically a settlement. So in this case, we have a $1.5 million civil money penalty that was enforced against Warby Parker. And at issue in this was an ongoing data breach issue that developed over a number of years. And essentially what was happening is what's called credential stuffing. So this is a kind of attack where passwords and other credentials are taken from typically maybe another data breach, and then those credentials are used to attack a website, for example, where there's a login and access those accounts. So Warby Parker was aware of this activity for a while and had been investigating it and kind of looking at it. But eventually, when they submitted a breach report, HHS looked into it further and determined there was a few different areas of failure. And one of those, of course, was risk assessment. That's a common issue. So a good risk assessment involves looking at all of the electronic PHI in the systems that the protected health information that the organization is processing and evaluating where are the risks. And like the risk of dropping this, this clicker as I'm talking, but where are the risks and identifying those and then addressing them and documenting all of those activities. So one of the highlights here is that there was a lack of risk assessment for ePHI. And of course, along with that, well, if you haven't done a proper risk assessment, you're naturally going to have insufficient security measures, and then from there, potentially breaches and other issues. So this was a recent case that illustrates, in the medical device supply area, a gap and ultimately some enforcement activity. Another area, this is a business associate example where Health Fitness Corporation, this business associate that was providing services to a healthcare provider, a covered entity, they had a corrective action plan and enforcement of around $227,000, civil money penalty. Between those two things, they, a sizable amount of activity to address the issues that were found and also a financial impact directly. And what was at issue here is again, there was a lack of risk assessment awareness of particularly how security controls were implemented, at the organization, and that led to a publicly accessible server, which should not have been publicly accessible to be clear, that was available through the internet, so web search crawlers, those kind of things that Google uses to develop its search results, found this server and then cataloged the data within the server. And so that obviously is not a secure way to maintain PHI, and that led to this particular breach. And that also, of course, leads to penalties and potentially litigation and all those associated issues. We have another issue, or another scenario here where a medical supply company had, again, a volume of PHI that was being stored within the servers. And this particular one I think is really interesting because there was such a large potential volume of data involved, and it came from something that we're all familiar with, a phishing attack. So as you know, phishing is a type of targeted attack where emails, or in some cases it's text messages, are used to attack a particular organization. Maybe it's more sophisticated now, especially with the use of artificial intelligence. But that essentially, through one of these phishing attacks, we don't have the exact details of that attack, credentials were provided that led to the breach of a significant amount of data. What also is interesting about this is the resolution agreement included 2 years of monitoring. So not only is there this significant settlement penalty, but also some direct enforcement and monitoring will continue for a couple of years after the settlement agreement. So we're going to shift a little bit. So HIPAA, of course, is a major part of enforcement, but also the Federal Trade Commission federally within the US is focused on all of really any sort of commerce. They're regulating that in terms of various fairness issues, and particularly in the privacy and cybersecurity space, they're looking at what are called unfair or deceptive trade practices. And that's regulated under Section 5 of the Federal Trade Commission Act. And again, the focus here is how does a company's activities when it relates to cybersecurity, the adequacy of that, could that be an unfair practice, and whether that leads to a breach or other potential misuse of information, that could potentially be an unfair trade practice, or the use of, say, information internally or through disclosure, especially sensitive information like health information that you might see at a manufacturer or other kind of health app or organization that offers healthcare services. the FTC is really focused on those kinds of activities and how might they be unfair or deceptive. And along with that, while the FTC could, in theory, regulate HIPAA-covered entities, what they're really emphasizing in their enforcement are those entities that fall outside of HIPAA. So we know that in the medical device manufacturer, pharmaceutical space, many of these organizations and our organizations are not directly regulated by HIPAA, and therefore someone steps in, and that's typically the FTC at the federal level. So in this particular case, we have an FTC order, and Cerebral is a kind of a mental health wellness organization that's focused on supporting these, through apps and through services, mental health. And additionally, a part of that is collecting large volumes of information related to mental health, which of course is sensitive, and the FTC is concerned about how that's protected and maintained. But the complaint that the FTC filed alleged that there were several privacy violations in terms of how that information was used and shared, and really focused in on some tools that were used on the Cerebral website and through their apps that led to sharing of sensitive information with these different kind of tracking tools through LinkedIn, through I think it's Facebook and or Snapchat and TikTok. So a few different tools that really, because of the way they're embedded on the web page or in the app, can share large volumes of data with third parties. And of course, that on its own, is not a great situation, but then there was also not consent or a significant awareness or acknowledgement of this within the privacy notices, and no explicit consent given for that sharing. Here, it nearly 3 million consumers affected by that. And so the settlement was around 7 million, which kind of reflects the volume of data and impact of this one. I think one other thing to note here that I highlighted in this slide is that the FTC didn't just go through the settlement side and require a privacy program, kind of the standard FTC approach, but they also added a ban on certain sharing as part of their, particularly with marketing, for marketing purposes, as part of their enforcement activity. Another kind of similar situation, Monument Health is a provider of services, particularly for those with addiction issues related to alcohol or other particular drugs. So there was a similar concern, again, that ad-based sharing or ad tech-based sharing of what, let's say you visited the website and you used their services, certain data from that was being shared with third parties like Meta or other advertisers. And a part of that was they had these sort of like session IDs or ways of identifying the purpose of the visit, which disclosed certain information about that individual's health. So it could be that they had a visit or that they paid for healthcare on that visit to the website. So each website visit would be linked to this, not only identifier, but also what their service they were seeking on the website. And so the FTC took issue with that, and eventually, as of June of last year, there was a $2.5 million settlement that resulted from this. Again, another online wellness provider. And I think helpful just to frame this, while these are not med device or pharmaceutical companies directly, this is the kind of activity that the FTC is looking at in terms of health information, where it's shared, the kinds of trackers on websites that are implemented, other sharing of data. And so here's another example of that. So BetterHelp, if you're familiar with BetterHelp, it's a mental health wellness kind of online therapy service where you can be connected to a therapy provider through the web app or through the mobile app. So here the issue again was that there was a certain amount of sharing, again for advertising purposes, that BetterHelp was engaged in, which the FTC again took issue with because they weren't disclosing it and getting consent from the users whose information was shared. So again, sensitive information about health and wellness and mental health was being shared with these ad tech companies. And kind of critically to this, a lot of times when this sharing occurs, if you're the company that's sharing it, you're thinking, well, look, Facebook or Google, they're promising us that when this data is shared, it's hashed, it's anonymized, we have no idea who it is. we're just using that data to help target to kind of a broad audience that fits these markers that might be in your data. But the reality is the FTC looks at that and says, well, hashing really isn't anonymized data. It's a way of reducing identifiability, but it's not necessarily anonymous data. And in many cases, the data would be provided to the ad tech service provider and then hashed. So there's often kind of an initial disclosure that's not protected at all, and then the hashing is a subsequent activity. But either way, the FTC has been concerned that, look, this isn't really an anonymization of data. And so this is a sharing that could be problematic. So one of the key things here too, and I think it's highlighted on this slide, is not only is the FTC concerned about kind of unfair practices, which are those that are generally not expected or kind of out of the norm from what a consumer might expect, but also promises. So if you have a website that says HIPAA compliant, or we keep your information private, we never share it without your consent, or you have these kinds of broad statements, or even specific promises that are very close to what you do but aren't exactly correct. The FTC is going to look at those and say, well, you promised those consumers that you wouldn't share this, or that you would keep their information private, or that your security was at this level and perhaps it was at this lower level. So whenever those kinds of promises are out there, you could find yourself in a deceptive trade practice scenario where your approach to that data and how you handle it doesn't actually match your words, and that is also a concern. So I keep skipping here. So we've got state enforcement trends. So we'll talk through a few of these. Mostly this is focused on California, but we do have a new, kind of a newer law in Washington that we'll look at as well. So again, a key focus area of these enforcement cases has been ad tech. And that's not to say that ad tech is the only issue, but it is a prominent concern, and largely because health information shared for ad tech is not controlled well in the way that most other kinds of service provider data is protected. It's shared and then usually reused for various purposes by the ad tech organization. So there's a major focus on that. But there's a lot of different avenues for this kind of sharing to occur. Here's another example of that. So Tilting Point Media is a company that develops games and apps. If you could analogize this, think about apps that you might develop in the healthcare space, whether it's to track patient outcomes, ePro, or it's something along those lines, or even maybe it's a patient-directed app that collects PHI or even personal data that's related to a drug or therapy or implanted medical device, different things that might be similar. So the development of those products really needs to keep in mind what kind of data is collected and how is it shared? Are there third parties involved? And these kinds of cases can be illustrative of issues that might come up. So in this case, we had a significant settlement from the Attorney General of California, responsible for enforcing the CCPA, the California Consumer Protection Act, and they looked into particularly how is this game developer and this app, how is it interacting with children's data in particular? Again, children's data is a major area of focus for enforcement for obvious reasons. And so they were concerned about some of this. So one of the focal areas is how is the software in this app, it was configured. Ultimately, it was configured in a way that didn't clarify the age of individuals and whose data was being collected properly, at least according to the Attorney General. And then when they looked closely at it, they found that data was being shared with third parties through the app in ways that weren't disclosed clearly or even consented to. Additionally, if you have a minor child who's engaged in the app and using the app, they may not even have the ability to give consent to sharing. They made it a parent involved. So there's kind of additional issues when a child's data is involved in the enforcement. And I won't lean too much into this one, but suffice it to say, California has been active in enforcement on privacy. So DoorDash as well. We have a highlight there. I want to spend a little bit more time focused on the Washington My Health, My Data Act. So uniquely, there are many state laws that address privacy, but very few that give consumers the ability to directly enforce those laws. For the most part, even HIPAA and in the Federal Trade Commission Act are enforced by government agents. So it's whether it's the Attorney General or whether it's the FTC. It's different enforcement bodies at the government level. But Washington has a privacy rule that's applied to consumer health data. That's a pretty broad definition, but it largely addresses any information that's collected about consumers within the state and then processed and handled. So this rule grants to any individual who's been, if there's a violation of that law, the right to pursue under the Consumer Protection Act in Washington, independently and on their own, a enforcement action. And so that's what happened recently. And the focus of this was Amazon because they have produced a number of different software elements, but one of them is a software developer kit, and that was used in a lot of different apps across app stores of different kinds. And included in that software development kit was certain data collection that relates to geographic location as part of that kit. And so by default, anyone who's using and deploying an app using that kit could be and would be collecting location information about individuals. Well, the argument in this case is that, well, certainly location alone might not be consumer health data. It can infer health information, like what if you visited a hospital or a particular provider, or and especially as you start thinking about specialized providers that maybe offer a unique service, there's more and more potential conclusions that could be drawn from that data. And so that's what the basis of this suit is. We'll kind of see how that plays out. It's in the midst of kind of early stages here. So some other enforcement, we'll look at GDPR. I think that's also very relevant to the med device space and pharmaceutical space. We have a few big cases. I think these tend to draw the most attention, those that get into the hundreds of millions. And so we'll talk briefly about these. Meta is one example. And so Meta's been the subject of a number of these enforcement actions, usually through Ireland because that's where their kind of European offices are. But we'll see that a major focus of these kinds of actions is usually things like lawful basis, the use of information internally and whether that's appropriate. There might be a lack of disclosure about what information is being used and the basis for that. Because GDPR is focused not only on security of information, but how do you use it internally, how do you share it, and is that all aligned with a really pretty strict framework around kind of justifying the use and disclosure of certain data. So a focus on these two actions here is a privacy breach. So in one case, there was a breach that impacted 29 million users. And the focus there was kind of insufficient protection of passwords. What I find interesting about this is it was an internal breach. So there wasn't actually disclosure of any data outside the company, at least that was identified in this investigation. However, this apparently 29 million individuals' passwords was stored in this server, and it wasn't encrypted. And so the mere fact that the data was available to others within the company and not protected appropriately that way, the DPC, or the Data Protection Commission of Ireland, considered that alone to be a reportable breach, not just a security incident, as we might kind of typically think of these internal issues, but a breach that should have been reported to the government. And so they, of course, cited failures to properly implement data protection impact assessment and address and identify this issue. Another one here is LinkedIn. As you know, probably know a Microsoft company. So again, a large tech organization. And this fine was based on an insufficient legal basis for processing. So as we've noted before, processing is largely the use or disclosure or handling of data. So collecting information is processing. If you process or analyze it in some way, that's a form of processing. If internally you grant access to someone, that's a form of processing. So it's a very broad definition, includes storage, maintenance, all of these things. Within this case particularly, there's a focus on insufficient consent. So if there's a use, in this case for behavioral analysis, identifying maybe some user tendencies, and then advertising targeted to those users, those would be processing activities. So then essentially under GDPR, LinkedIn would have had to identify certain bases, whether that's, hey, our legitimate interest to use this data for business purposes, in this case, advertising, outweighs the individual rights of this data subject. Therefore, we have a legitimate interest to use this. That's kind of the legitimate interest analysis. On the other hand, there could be a failure to get consent. So let's say they said, well, you don't actually have a legitimate interest, which happened in this case. So you needed consent to do this processing, this behavioral-focused advertising, and therefore violation. So that's really the focus in this case, is use of data within LinkedIn that the Data Protection Commission identified as lacking. You didn't pick the right basis, therefore you didn't have consent when you really needed it. And then a few examples from MedTech I think will be helpful to kind of frame this better. So a few different fines that I identified through some research. And if you go online and look for GDPR enforcement trends, there's well over 2,000 fines or penalties that have been issued over the past several years of enforcement. Most of them smaller, and some of these are kind of middle of the road, but you can kind of see that there is active enforcement. And it's not surprising if you think about how many enforcement bodies there are across the European Union. There's 23 alone in Germany, and then there's individual oversight within each member country. So there's quite a bit of focus on enforcement. So these are just a few examples of many, many enforcement actions. In one case here, Argon Medical Devices, there was a 220,000 euro fine, and the focus of this was a failure to notify quickly enough when there was a breach of the employees' data within the company. And so GDPR requires 72-hour notice to the data protection authorities when there's a breach, and that didn't happen in time in this case. In this medical lab case, 20,000 euro fine, so a smaller fine, but the focus of this was data protection impact assessment. And so really something pretty basic, looking at a processing activity, something related to personal data, and then identifying that they really didn't assess this activity properly. And therefore, also missed some other kind of basic compliance elements. And then MedHelp AB, this was a larger fine, 1.2 million euros. And this was focused on a telephone hotline. It was essentially a company that provided medical consultation through phone. And one of their service providers had a breach. And the breach, bubbled up, they had to report it. But eventually, it ended up being found by the Data Protection Commission or Data Protection Authority that this particular company had contracted this to a third party, but failed to adequately vet that company, ensure that there was security in place for the data, and then also lacked the right kind of agreements and controls to make sure that those same protections in, I believe this was Sweden, in Sweden, were transferred properly to that third-party company. So again, focus on these kind of areas as you're developing your compliance programs. So within all of these, there's kind of a key theme. We have these data protection programs and privacy programs that are needed to establish the framework. From the very beginning, the FTC is looking at, okay, what kind of data use is going on and sharing, what's collected? Are there controls around that are adequate? And so each of those FTC enforcement actions, each of those HIPAA compliance enforcement actions, each of the GDPR enforcement actions are all looking at what is in place at the company and requiring, in many cases, that something be implemented. And it's pretty robust. If you look at some of these complaints and how the settlements eventually shake out, there's pages of requirements for these companies to implement a privacy and cybersecurity program. And then if you're doing processing, especially in Europe, but even in the US, do impact assessments or security risk assessments or both that focus on how is the data processed, what kind of security controls are in place around it, and then develop accordingly so that you're addressing those risks. And then lastly, look really closely at your plans around security and how do you address incidents. If there is a security incident, how do you respond? Will you timely address it? A couple of these were related to failures to notify or delays in notifying, whether it's HHS, if it's a HIPAA violation, or the local authority under GDPR. So be prepared for those. And then lastly, look at your third parties. A number of these breaches And most breaches seem to occur through a third-party failure. So have vetting processes and have good agreements in place to protect the company in case there is a breach. So I think I'm all done with the presentation. If there's any questions, I think I'll take those later when we have a chance to discuss, or feel free to shoot me an email as well. All right, thanks everyone.
Thank you so much, Paul. So we're going to now jump into our panel discussion, which will be led by our founder, Mark Gardner, and he'll be joined by Bryan Phillips from Inspire Medical, Wendy Cusick from CoNextions Medical, and Jonelle Burnham from CVRx Barristan. They'll be discussing the latest in compliance, enforcement, and legal strategy.
Hello, Janelle, how are you? Really? That's it? We go way back.
Oh, they want that there. Okay, sounds good.
I'll get Bryan.
Is this live? Okay.
What are you guys worried about?
All right. Well, I'm very excited to have my esteemed panelists here, Jonelle Burnham from CVRx, Bryan Phillips from Inspire Medical, and Wendy Cusick from CoNextions Medical. Just a couple comments before we jump into it. If you smelled something during the program, that's beer meat being made. I know that because I grew up in La Crosse, Wisconsin, which is where Old Style and Special Export, if you remember those beers, that's where that's made. And I remember smelling this like as a kid. I just thought it was normal for your town to smell like that. Also, just thanks to Charlie and Karen. They've really been the ones that put the food together and have been making everything running really well today. So thanks to them, and thanks to the whole team. I have the luxury of just showing up, and Darya and Amanda, everyone doing such a great job. Thanks for that. We're gonna have a happy hour after, and it's right outside this room. Karen was just telling me we also have a patio out here. Thank you, Charlie. And so mingle, talk to the person next to you. We also we have reserved from 4 to 6. Now, I don't know if anyone needs to be here that long, but I'll have to wheel you out. But, and that's kind of outside where it's sort of indoors, outdoors, downstairs. So it is a nicer day. Thankfully, it stopped raining. And then finally, Darya, you're going to announce some Kahoots results after right when we finish up. And so for the local folks here, you'll get some prizes. And very lastly, you can download the slides right now online. I know that was mentioned earlier, but Charlie's also going to do a recap and follow up after the program, so it'll be emailed to you. So if you want the slides and a recap of the program and videos and all kinds of things, that will be emailed to you from Charlie. So without further ado, I'll jump right into it. And I have the first question here for you, Jonelle. And maybe before we do that, you all have your mics. Why don't you briefly introduce yourselves to the audience?
So I'm Jonelle Burnham. I'm currently general counsel at CVRx. It's a small device company in Brooklyn Park. I met Mark in or around 2012. And he was like, I was working at a dental company, and he's like, you should get into compliance. And so that was interesting, and it laid a nice and fascinating path. So I'm grateful for that, and privileged to be here today, and I love getting together with peers. So looking forward to talking to you. Thank you. Thanks for the invitation.
Good afternoon. My name is Bryan Phillips. I'm General Counsel, Chief Compliance Officer at Inspire Medical Systems. Happy to be here amongst such esteemed panelists. Jonelle, your story is interesting about having met Mark. I met Mark a couple of years ago, and his comment to me was, you should get out of compliance.
Hi, my name is Wendy Cusick. I'm currently with CoNextions Medical, trauma and extremities company, but prior to that, I was with a local company called Spinology for about 15 years. So I've spent most of my time in spine, orthopedics, and trauma, and have been working with Mark for a very long time on the regulatory side. I mean, at least 10 years.
Yeah.
Yeah, lots of good guidance over the years.
Thank you. Thank you. I'm going to start with you, Jonelle, with the first question. So based on the sessions today, great job everyone on those. What recent enforcement trend are you most concerned about, and how is your organization responding to it? And by the way, today, these are all their comments, their personal comments, not representing their organizations necessarily.
I like how you disclaim us out of the box. So there is no rest for the weary, is one of the things that became really clear. Like, despite what may look like not great organization and a sense that's a little chaotic, it does seem clear that enforcement efforts are continuing in this area, and we need to be careful and vigilant. One of the things that we're going to do at my organization is we're going to pick up and we're going to poke and prod around at our speaker programs again, because that's a place where there seems to be some effort and energy. One of the things that I have long been intrigued by and interested in is the Open Payments / Sunshine Act. I remember sitting locked in my house in 2020, I think it was September, and seeing the Medtronic case. It was $8 million for kickbacks and $1 million for what I think was the first prosecution under the Sunshine Act that came out. And that is such a treasure trove of data. And now with AI in place, I can only imagine what somebody could do parsing through it. So I think that's kind of an interesting area that I was thinking about today as we were talking about the FTC and what it was looking at doing with AI, and so AI in that space. And then another area that we've been thinking about that is in the undertones of the discussions this morning is fair market value everything, right? What do you have for fair market value, and how are you substantiating it and using it? Are the thoughts that came to mind.
Thank you. Anything to add, Bryan or Wendy, to that?
I'd add, and I agree with Jonelle. I think even without the chaotic environment in D.C., it would be reasonable to anticipate there to be a return of a pendulum, even if there were some change in enforcement attitude by the current administration. And recently, as recent as a couple of weeks ago, right, there was re-emphasis for healthcare compliance generally as a priority area for the Department of Justice. So even with the chaos that exists, what remains a focus for the DOJ is healthcare compliance in the areas in which we all dabble. Specific areas in our company that we're continuing to pay attention to, Jonelle's examples are great ones, the speaker programs, excellence programs, things like that. Anytime the business is looking to designate and identify any of our customers as being special for some reason, and with that comes some recognition, right? You need to be careful and scrutinize the criteria that are used and how that's communicated, whether it's communicated through the corporate teams or hopefully not through the sales organizations, and minimizes their involvement in how those programs are administered. But generally the enforcement environment, while in certain areas there may be some chaos and lessened attention for healthcare compliance, it remains a priority.
I echo those sentiments, of course. In my particular field, the use of 1099s and distributors is commonplace. It is the rule and not the exception. And so managing the relationships with those sales agents is always tricky, not only in how they are being compensated, but in their behaviors as well. And in the small to mid-sized companies, there tends to be a tendency to want to just look away, and what you don't know can't hurt you. But with the increased spotlight on these activities and these cases coming out, it's figuring out ways to put systems in place to get the right disclosure from these third-party distributors to understand where they're spending their money, and to get our internal sales managers to understand that we're responsible ultimately for that behavior. And this is not necessarily a new risk, but it's a refocused risk with the way the enforcement trends are going. And there's been, ever since I've gotten into this, I think, the government has sort of felt like they did a decent job with pharma and kind of getting a handle on how the pharma reps are paid. And they've had their bullseye on the device reps, right? And they've wanted these device reps to get off these commission plans. They want vending machines in the OR where you just, and that's just not realistic. And it's not safe for the patients either. There's a reason these device reps are in the rooms a lot of the times. So managing that risk and balancing that is a big focus.
Yeah, that's a great point about the device reps. I was actually a former product manager and worked a lot with sales reps in the field and would cover cases where I was a guest in the OR or cath lab. And on many occasions, I saw them helping the physician, pointing things out that maybe the physician or scrub nurse or whomever just didn't see in it. There's a great value that they add to the patient safety, in my view. Next question, I'll toss this over to you, Bryan. How do you balance legal risk with the business's desire to move quickly on product development and market expansion? So businesses always want to move fast, right?
Oh my God. Always want to move fast and hyper fast when you're in a smaller, fast-paced, high-growth company like mine. And just for background, for those that aren't familiar, Inspire was founded as a spin-out of technology and products from Medtronic in 2007. All pre-commercial, still at the time in clinical stage and working through the regulatory process. Ultimately got FDA approval in 2014. First products were sold in 2015. The company went public in 2018. I joined in 2021, January 2021, and we had just finished 2020 with $115 million in revenue.
Wow.
That was just 4.5 years ago.
It's a great market space you're in.
Right. And in 2024, we announced and had revenue of a little bit over $800 million.
Wow.
So in the span of 4 years, we've grown. I don't know what that compounded annual growth rate, I'm just a dumb lawyer, but the growth is exceptional. And with that, comes all the pressures of fast-paced product development teams and marketing teams that want to do more and all of those types of things. And so the risks and our role as lawyers and compliance professionals to oversee and work with those teams just continues to get more complex and evolves as the business continues to grow. My personal view is ways in which we can support the business and help to manage the risk is to do what we all know and what we all talk about, but we all recognize you could always do a better job, which is integrate, the legal and compliance teams into the product development teams as early as possible, and throughout the entire process. So, right, you don't want to just be in the very first kickoff meeting and then show up, 6 to 12 months later once the product team is committing to a certain design. But stay connected. Figure out ways to stay connected. Work with the leaders in the organization who have responsibility for governance and decision making to figure out how you can establish appropriate governance structures through the process, whether it's a committee that includes legal and compliance representatives that meet periodically to talk through issues that the design team is facing. But by all means, avoid the scenario where you're called in weeks before, right, the submission needs to go to FDA, or weeks before, the contemplated launch of a product to sort of wrestle to the ground, significant issues. That's certainly a big piece of it. I also sort of couple that with, any risk management has to be aligned with, a well thought through assessment of where to focus, like a risk assessment, right? Not all risks are created equal. Not all areas associated with product design are going to present the same level of risk and magnitude to the organization. And so you need to be thoughtful around where and how to focus your energy and where are the areas where you can accept a degree of risk beyond what generally might be thought of versus areas where you just simply can't tolerate the risk. And just by way of a general comment, this is an area where I would say we are continuing to have discussion, and I haven't figured out exactly how to engage with the organization generally on risk management. It's super easy in the context of a single decision, a single issue on the table to reach a conclusion and accept the risk associated with that. The challenge I think most organizations have, including my own, is when you think about risk in the aggregate, right? So that you've accepted a level of risk in one area, in area A, area B, you've got a certain level of risk, and before you know it, if you haven't thought about it in the aggregate, your overall risk profile, likely or may exceed, the appetite that the organization has for risk. So you have to somehow work into how you think about risk, this idea of cumulative aggregated risk across the organization rather than for any specific decision to sort of advising on the risk and then making a decision. I think eventually that you'll run into issues with that approach.
Excellent points. Yeah, no, it's so many good points in there. But yeah, we've all been a part of those conversations where maybe the commercial's shot or whatever it is, and you're brought in at the 11th hour and you're like, whoa, sorry. So to your point, getting in early and being that advocate for the team is critical. Anything to add, Wendy or Jonelle?
Great answer.
It really was. I mean, I think the only other nuance I would add to that is the relationship building that happens in the course of that and making it clear to the team, in particular the commercial team, that you are their ally and their advocate and not their enemy. And I think the sooner you can establish that relationship, that you're there to remove obstacles from them, to keep everybody out of orange and not necessarily to put roadblocks in front of them, that will move mountains in the long run.
I think it's a great point. And the smart commercial folks will figure that out quickly too and say, how can I work with my legal and regulatory colleagues? Because they're ultimately, I need to convince them that what I'm doing is okay.
Can I just add a nuance points to Wendy's really good comment? I encourage, and I'm looking across the room and not directly at folks from Inspire, but I've got a table full of folks from Inspire here. And I think they would vouch for the conversations that we've had, similar to what Wendy just described, where we don't consider ourselves apart from the team. We are part of the team. It just happens to be that we've got background in law and compliance, and that's our area of expertise, but we are as accountable to helping the business achieve its goals, right? And I think that's a big part of what Wendy just said. If you show up and all you say is, hey, look, here's the law, here are the issues, it's your decision, then that creates a separation between you and a mentality that the business folks have that you're perhaps not accountable to the fact that a no decision or a decision where you've got to go and do some type of redesign impacts them, but it doesn't necessarily impact you, right? Because you're just calling balls and strikes. So that's, to me, how you show up, how you engage is critical, being part of the team.
Thank you. Wendy, I'm going to jump over to you. And we have a list of questions here. This is a great conversation, by the way. I hope we can get through most of these, but I'm going to jump down the list a little ways to what's one compliance or legal risk that you think is underappreciated right now in the medtech industry? And I know we talked about food and drugs today, but we've got a lot of medtech folks I know online and here in the room. So if you don't mind tackling that one, Wendy.
Well, I mean, I think with the exception of Paul, probably, the cybersecurity issue, I think, is huge. And we talked about this just for a second when we were speaking. And I think that there's obvious things. If you are in an implantable that has a software component to it, you're probably a little bit more attuned to this, right? And I think there's things like HIPAA. But Paul did a great job diving into how scary this gets fast for all of us. And I think we're really woefully unprepared for it generally as a bar, if you will, as a group of professionals, if you will. I think understanding how AI is going to impact this, we're all collecting data more and more frequently, whether it's from a clinical trial, whether it's post-market surveillance, whether it is actual biofeedback from the devices itself. The amount of data we're collecting in this industry is staggering. And I think we're just in its infancy in figuring out how we're going to use it, how we're going to share it, what's okay, what's not okay. The rules are evolving as well. And so I just think as an industry, we're all trying to get our arms around it. I certainly don't have any answers, but I'm aware that this is an issue.
I so agree with you. And I think the other thing that we like to do and take comfort, and it's the way we've handled things in this past, like, oh, I'll hire somebody and I'll have a specialist over here. And you think like, oh, in this organization, you're going to have this one person that's going to take care of all of this for you. And I'm coming to believe, and I love you enthusiastically laughing and agreeing with me, I think.
He's the one person I hired.
Yeah, okay. That's why he's laughing. I think what we need to start doing is telling everyone, this is all of our jobs. No one area, no one person can do this, and everybody has to develop this savvy because it's going to take all of us.
Nothing to add, really. I mean, I'm happy. I know Mark was concerned because I just showed up a few minutes before the panel started. But that was intentional because I wanted to avoid Paul's very scary commentary around data privacy and cybersecurity issues and concerns. I've got nothing to add. I completely agree with the comments from the
Excellent, excellent. Jonelle, I'm going to come back to you. How are you leveraging compliance training to reduce internal risk, and what's actually working with your teams? Maybe what's not working, if you'd like to talk about that.
So one of my favorite things about compliance, and this actually caught me by surprise, is training. I absolutely love training. I apparently love acting. I love if I can do a training and afterwards, or lead a training, or my team does a training or whatever, and afterwards people come up and say, that was the best compliance training, or that was so much fun, or I can't, like, that is just this huge payoff, because what that means is people aren't training. They're learning something, they're getting to know something. And so I spend a lot of time, probably some would say too much time, but I think it's super fun, working on trying to come up with creative trainings. One of my favorite trainings was, came out of the Acclarent off-label case, and I was new and I had just started at this company, and I went in to meet the sales leadership team and turned it into a closing argument in an off-label case prosecuting this company. And that group was, there were, I don't know, 30 of them in the room. I'd never met most of them before, and they were rapt. And I finished, and I was all excited, and I was like, wow. And I heard quietly somebody goes, are we in trouble? And it was just, and afterwards, what somebody said to me was, you made me feel like crap. And afterwards, I realized I never want to feel that way. And that made a difference. And so all the things that we can do to make people feel something during the training, to lean in and really, I've had fun with this. And one of the things I'm thinking about lately, as everybody's doing more with less and faster, is trying to incorporate more bursts of training. Not you have to come for an hour session, but what can I send out, right? Mm-hmm. Here, if you submit this response to this, you'll automatically, whether you're right or wrong, get in this thing for $200 gift card if you complete the exercise. And what can you learn? And people realize, some of them, they don't know what they're doing, right? So when you say, here's the follow-up session, join this short call and we'll explain it, they'll join the session. But what are you guys doing?
I love that. And I especially like the aspect of your description of the importance of training, and how when people have gone through a session, they don't realize that they were training, and how it just simply connects to their job. And I think that applies to all aspects of it, whether it's how the training itself and the materials for training are delivered, even our policies, right? We need to work, and if we're honest, we lawyers and compliance professionals, we love policies, but these things don't exist for us. They exist so that folks on our team throughout the organization can read and comprehend and get the information that they need to successfully do their jobs. And if it's written in a way that it's only going to be understood by lawyers, or in other convoluted ways, then we're standing in the way of helping people understand what they need to know to do their job successfully. So I think that's a critical component of it as well. I love this burst training idea, and I'm benefiting from, I've got a table full of folks over here to my left that are hearing all of these ideas real time, and I get to endorse them in front of them.
I would echo that too, and I think real time is another thing that's important. One of the most entertaining, annual compliance I did was the oldie but goodie, the Hall of Shame, where you trot out all the nonsense, right, anonymized.
All the emails.
All the emails, all the nonsense, and the sales reps love nothing more than trying to figure out who did what, and no one wants to be up there. and it's a great sense of accomplishment by the time you're done with that, because everyone is like, but along with the burst training in that same vein is real time. So when something happens, we had a product that was sold commercially off label for almost 15 years. So you can imagine the nonsense there. When it got its de novo grant and we were able to market, there was actually more nonsense, because it's easy to say you just can't promote. Now all of a sudden when you can promote, there's a lot more to do. And we had a sales call where someone was raising issues, and I think as frequently as you can, attack them right after it happens. Like, you just said a whole pile of bad, and I need to undo this. To do some sort of burst training immediately after that while you have their attention is fantastic. And again, I'm in small, mid-sized organizations, so we can be a little bit more nimble in that regard, but it's effective, I think.
Yeah, I think you're right. It can be really effective because a lot of times something happens, the sales force, they might be talking about it, depending on the situation. So you can take advantage of telling them all at once, hey, we need to retrain. Maybe even, depending on the situation, you have a heavy hand or a lighter hand, but it can be a great opportunity to strike while iron's hot, if you will. All right, Bryan, I'm going to come back to you. So looking ahead to the next 12 months, it's hard to believe we're almost halfway through 2025 already, but what are you watching closely, whether it's legislative, regulatory, or enforcement related?
I would say, and we've already touched on it a bit, the general sense of enforcement trends, where the areas of focus for the regulator is going to be. Where's the state of maturity of our compliance program relative to where those areas of interest might be, and the things that we can do over the short and near term to augment and get better as quick as possible, and support the business, right? Because the business is growing and it's changing, and all of those things that we've already talked about. And so it's always a challenge to stay in front and to allow the maturity of the compliance program match where the business is, but that's the ask, that's the goal. One of the things also that is, I think, forefront for a lot of us, and Jonelle mentioned this earlier, is artificial intelligence, right? And AI can be used by regulators to enhance their oversight and view of what companies are doing, but there's even an expectation now, I think most of us appreciate, for companies to utilize artificial intelligence as part of our monitoring environment, right? And so, I've got situations now where, had we made different choices over the course of an investigation to utilize AI-type tools, we might have learned things that would have led to perhaps a different conclusion in the investigation. That's not bad per se, but again, that expectation on the part of regulators that companies like ours make use of these tools to, bring to bear and have as part of your compliance programs effective oversight and monitoring is just going to be important for us. And those tools are evolving and growing, and the ways in which you might leverage them will continue to grow as well. So,
good comment. One of the things that I've been thinking about, you mentioned effective compliance program, right? And that's one of those things that always makes me want to roll my eyes, right? Because no, I'm trying to run an ineffective, of course I'm trying to run an effective compliance program, right? But I was looking at I think it's 2020, November of 2023, OIG guidance on an effective compliance program. And I think there's something like 300 and however many shoulds in that document, and you can take that document and you can divide it up and you could say the CEO should, the board should, the compliance officer should, the compliance committee should, and employees should. And I think in some respects, maybe some people are doing this already, but I'm toying with the idea of what would happen if you take that document and you evaluate it against, because I hate this idea of hiring somebody to come in and learn all of these things about my company and then just tell me, right? So how can we audit and look at our effectiveness and learn from it ourselves? And so that's just an idea I thought I'd share.
Mm-hmm. I like that.
Yeah, I can only imagine some of the tools the government's now using for discovery. Back in the day, it was like we took the servers and we have all your emails, and now it would probably take seconds to find the most damning emails out of these billion emails. Or maybe not billion, but a lot of emails. And I would imagine it would do a pretty good job probably finding them. So
some of us made a really good living in litigation world reading paper documents not all that long ago. So
yeah, no, right. Okay, I'm going to flip it over to you, Wendy, and talk a little bit about the FDA. In the evolving FDA regulatory landscape, what's one thing your team is doing differently this year compared to last?
I mean, come on, right? I mean, going slow is what we're doing because nobody has any idea. The company that I'm currently at right now has tendon repair products that are cleared for the hand and the wrist. They're pretty awesome, actually. But they very much want to move to foot and ankle and tendon to tendon Achilles repair and stuff. But we are at a little bit of a hang on. What on earth is going on over there? And not even considering doing anything without pre-subs first. I mean, it just feels like we don't know what's going on. I think you're going to see probably a lot more business, Mark. Right? I think we're going to be depending on outside counsel a lot more and getting these opinions about what to expect because that's what it feels like. So it's almost like a go slow to go fast. I think there's some trepidation. There's a lot of concern about missteps and what's going to happen. And that's not even taking into account the discussion from earlier about the staffing and the AI and all of that, but how the rule changes are going to affect things. I just feel like there's so much unknown that we're at a little bit of a pause.
Yeah, it's a great point. And I know earlier the group talked about what you take away 10 regulations, Nate, for every new one, and I'm not really sure how that's going to work. But yeah, so it's an interesting environment right now. Anything else to add on the FDA front?
I want to know how Wendy is successful in convincing the business to slow down.
Yeah, you guys will have to talk at PR about that.
Money. We don't want to waste money.
Yeah.
Right? That was the bottom line. Budget.
We have a team who's reporting every time they engage and telling, and then reporting out what we can expect next. And so far, they're braced, right? But so far, they haven't reported that they've encountered huge problems, but they're ready for it and trying to plan ahead.
Yeah, that's not to speak for the team, but I know they put out an alert that reviewed data for timelines not too long ago, and they're still the same, but it's still early days, so early innings. So we'll see where things wind up.
I should say, just as a point of clarification too, in my very specific case, there's a hope that we might not have to do some clinical work.
Sure.
And so with the changing in the regulations, we might avoid it. So that is part of the leg too.
That whole strategy is premised again on trying to go as fast as possible. Avoid doing the clinical because that will delay the timing of getting the submission in. But I think it is still a partnership, right? We talked about this earlier, partnership and working with the appropriate functional teams in the organization to figure out the right strategy and understand, the consequences of the various decisions that you're making, right? And risk ultimately if the regulator decides that you do need clinical data, right? And what does that mean? Well, you're going to add 2 years to the overall timeline. And you just want everybody to make those decisions eyes wide open, rather than it being made in an organization where it's everything is funneled through a single person or a single functional group without the benefit of real cross-functional input.
Yeah, great points. All right, I'm going to come back, Jonelle, to you here. So talking a little bit about corporate culture. When you see regulators focusing more on corporate culture, some of the cases highlighted by Man and Katy earlier, how do you promote a culture of compliance without being the Department of No?
So this is my leadership team, right? Giving my leadership team the opportunity to be the compliance leaders so that the teams are getting the message from all sides. This isn't the compliance department. This is all of us, I think. And so giving them the opportunities to look really good and clear messaging and share with them, I think is the best one I can think of. And that's worked pretty well.
Do you ever scare them into compliance, or are they just into it?
So, you know what? They're into it. Like, it's pride in the company. We are, I know a lot of us are, right? But patients first, like if you really mean patients first, that makes compliance a whole lot easier. And so when you've got people talking the talk and walking the walk, it kind of comes naturally. And so if you just coach them and give them the opportunities, they go.
I scare them. I mean, I think I've had a lot more success with the internal group and rallying around patients first and safety and efficacy for the folks that are in the building. For the folks that are on the street selling it, sometimes you just have to be the big bad wolf. And they have to know that there's consequences. But again, I spent a lot of time in spine, and the gross generalization there is they are cowboys. So,
Cowgirls too, right?
I mean, a couple. I use that word on purpose. Yeah, I mean, there's a couple cowgirls, but it is mostly cowboys, even in 2025. And so you do, especially, I mean, frankly, being a woman in that position, you do have to be a little with that group of people. But the other thing that I've found to be really helpful, and in particular with the rise of the key TAM suits, you mentioned being a product manager. Very often, the folks that are the product managers, the folks that are the med ed, admin assists, they get mad and they get disgruntled when the rules aren't being followed, when they feel like they're being asked to do something that seems a little shady. So pay attention to those people and make sure they know they can talk to you. Make sure they know you're taking their concerns seriously. Make sure they feel seen by you and heard by you, and that you are taking this seriously. The leadership team is walking the walk and taking it seriously. But very often it's those folks that end up picking up the phone. And so to just sort of be mindful of them and inclusive of that group, I think is important.
Well, such a great point. And part of the question, Mark, you used the word culture. And in my past, I had the opportunity to dabble in HR. And so I've spent a lot of time thinking about culture and have come to appreciate that culture is more than just a word. It's more than a handful of values that you might put on a fancy placard and post on a wall. It really is, at the end of the day, the behaviors of the individuals in the organization, primarily leadership, I would say, because the leaders in the organizations are the ones that cast the shadow and drive what others are paying attention to. And so that circles back to what both Jonelle and Wendy have said, which is the importance of when there is an issue, you have to take action, because by the time, candidly, my experience tells me that by the time it gets to my desk, I am not the last person to know, but I'm near the last person to know, which means there are a lot of people in the organization that are aware. They saw that sales rep do something that they had no business doing, and perhaps the sales rep is talking with other sales reps about how they did X, Y, and Z, and then it gets to your desk. And the people that are hearing it, that are trying to follow the rules and do the right thing, they're wondering, what the hell's going on? Where's leadership? Where are the consequences to this type of behavior if the value is compliance is not an option, which is one of ours, right? Then how can you tolerate, how can you stand up for that? And so we've got to have the courage to assure that the behaviors that the behaviors that people are demonstrating in the organization are aligned with our expectations and our values. And if they're not, even if it means tough decisions, you've got to be prepared to make those tough calls.
Yeah, no, great points.
Can I make one more tiny point? Another thing that I think some of us are up against or have seen is this idea that if somebody raises an issue, they're ratting somebody out. And we've done a lot of work to say, no, that is pride in our organization. That is making sure that we are doing the right things the right way. And when you're doing that, you are standing up for the organization and trying to kind of flip that idea on its head and make it more of a positive as opposed to some sort of disloyalty to somebody. And that's been really effective.
Yeah, no, great points. And I do agree, like, sometimes you have to, sometimes it's sugar and sometimes it's spice, right? And in our rules, it's often more spice, but showing.
And it's knowing your people too,
Yeah.
right? It's knowing your people. I mean, if you're in a small to mid-sized company, you actually know the people. And so you know who needs the sugar and who needs the spice.
But it is a good reminder for them, and you all can use this in your work. You know, sometimes people need to be reminded that they are personally liable. We act as contract counsel often for startups that don't have the budget to have an FTE, and we will need to remind certain people you're personally on the hook here for the misbranding or the kickbacks. And the kickbacks aren't just for your liability in the companies, it's the recipient. And just offering it is a violation of the law. So but at the same time, as we talked about earlier, trying to work with them so that they don't feel like you're just sales prevention, that you're just the culture of no, that you're there to protect them. You're there to protect the company, but also them, and keep everybody out of orange, as Wendy pointed out. So great comments there. And I do remember, too, as a product manager, when the AVMED code went into place, I was at EV3, and I was so happy because I didn't have to deal with pens or reps telling me that the pen that I picked out wasn't something that they liked. So we're getting close to time here. I'm looking through my list to see if there's anything else. I guess I'm going to come back to privacy one more time. I know that was a hot topic today. And just curious if there's any more tidbits you have on, and maybe with Wendy, I don't know that your products really are collecting patient data, but the question is, with data privacy compliance, when products generate or process patient data, if you're approaching that with auditing or are using software tools to make sure that the interactions are compliant, any tidbits to offer the audience there as that area evolves and really unfolds?
Mine aren't. You're probably more.
I got to be careful because I just left a conversation not too long ago on this very topic with that gentleman there. That I keep pointing to my team, and I'm going to have to apologize to them later. But it's largely consistent with what we've already described. For privacy, it's what I just mentioned for risk and product development teams, and integrating the privacy personnel into the design team to help make sure that you're thinking about privacy up front. It's sort of the idea of privacy by design, right? It's incorporated into the design of the product up front rather than something that's added to it either later in the development stage or perhaps even later than that. Doing the risk assessment, right? Because again, you can't do everything. You can try to do everything, but I think if you do that, you're going to end up in a situation where perhaps not everything is done well. And so being very clear in terms of where the risks are and the things that you can do to mitigate those risks as reflected in the design of the product. And then the idea of partnership as well, just being available and integrated into the teams and being accountable to ultimately helping the business be successful.
Great, thank you. Last question, because I know Charlie's showing me we're just about at time here, and I'll just maybe a quick response from all of you, starting with you, Wendy. So there's been more OIG activity, as Amanda reported earlier. We're at record highs for whistleblower cases, and if you violate the False Claims Act, if you violate the AKS, you violate the FCA. It's written into the law. Has that changed how you structure commercial agreements or physician interactions? How your salespeople
yes and no.
interacts?
I'll be quick. I mean, one, I'm going to go back and reiterate to this, the sort of key TAM prevention to the best you can with the relationship with your internal employees. But key to this too is the relationships with the HCPs. Because let's face it, none of us would pay these people if we didn't have to, right? We're not like trying to spend our budget paying physician consultants. They want to be paid, right? So having that conversation with, in my case, these spine surgeons who have very lofty ideas of how much they should be paid per hour, making them understand the risk it poses to them as well.
Thing to add? Closing comments on this question?
Well said.
I think meeting those safe harbors is critical, and something we've done for several clients. Submitting advisory opinions, they've been pretty quicker than in the past. I've had some take many months, some almost 2 years, but I think the last couple we've submitted have been around like 7 to 12 months or so. So using the OIG as a resource is also a good idea, because if you give them all the facts and they sign off on your program, the likelihood that you're going to have an issue is quite low. Well, thank you very much to our panelists. Please join me in thanking them, and I'm going to hand it over to Darya.